certain post-mortem fact has occurred. Two of the candidates have been selected. But I want to make them as a private respondent in this petition. So leave the gun because the order of 16 July. Yes. The writ petition was filed on 28th July. 29th, the very next day, they have issued this order selecting two candidates for the subject post. They are proper and necessary parties so far as the present proceeding is concerned. More particularly, Lordship, serial number 1 and 2. So far as waiting list candidates concerned, the right has not been crystallized. So far as 1 and 2 are concerned, they are a necessary and proper party. Leave be granted to the writ petitioner to bring these two persons within the area of the respondents of the present petition. Because in absence, Lordship.
Mr. Contempt is appearing in this matter.
Yes, my lords, I am appearing for the administration. Here, my lord, the interim order was vacated even earlier by the division bench. But of course, I agree with Mr. Jaipal that those private respondents are necessary parties, my lords. Their rights will be.
Let them be added.
Yes, my lord, my lord.
Are we audible? We are audible?
Yes, my lord. Yes, ma'am.
Learned counsel for the petitioner submits that after the writ application was filed, two candidates have been selected for the posts of for the vacant posts of Labor Department of the Andaman and Nicobar Administration. Prayer of the petitioner, liberty is granted to implead the said two candidates as added respondents in the writ application. The petitioner is directed to serve copy of the application along with annexure thereto upon the added respondents and file affidavit of service on the adjourned date. Next, sir, the matter be placed before the next available.
Lord, I may be permitted to correct the cost title of the writ petition. So
after that improvement is stated, the cost title of the writ petition be amended accordingly.
I'm grateful. I'm grateful.
Next.
My lord, I am appearing for the writ petition, my lord. Here, my lord, there is a private added respondent is there. My lord, we have sent it on 29th.
Not served as yet?
No, added respondent is present, but he said that service was not received to him because the address which was furnished, we have sent it through speed post on 29th July. So, my lord, I am seeking for an interim order. I can serve a copy to him, my lord.
Madam, मैं already वो copy देख चुका हूँ government response के through. मैं time waste नहीं करना चाहता हूँ.
Then I am placing my case, my lord.
आज ready है आप? और आप खुद ही submission करेंगे या?
In the trial court also, before the tribunal also, he engage advocate, they file affidavit, then he appear in person. My lord, he
is the private respondent, right?
Added respondent, my lord. Only added respondent. Yes. My lord.
And for the other respondents, you are appearing?
Yes. My lord, I am seeking for an interim order because all along during the pendency of the case before the tribunal, there exists an interim order. Now, my lord, the facts is such, my lord, these petitions were engaged on contract basis on and from between 2003 to 2013 under the respondent authorities on compassionate ground. Since the government servant, deceased government servant died and thereafter for the purpose to come out of the economic distress, my lord, they were engaged on contract basis. They worked continuously for, my lord, some of them worked for more than 20 years, my lord. Now, my lord, right from the year 1958 onwards, there was a compassionate scheme, appointment scheme, my lord. Ultimately, a compendium was prepared in the White Office Memorandum dated 2nd August 2022, whereby said what would be the modality to appoint on compassionate ground. Now, my lord, the paramount ground, the consideration would be that appointment ought to be on regular basis. Second, my lord, they have to promulgate their own criteria. What would be the criteria so that such appointment could be made? These are the two paramount grounds, my lord. Now, admittedly, there is no appointment on daily rated or contract basis under the compassionate appointment scheme. So when we are working from last 20 years on contract basis, then you have to consider this, that at no point of time the modality was abused by you in the last 20 years. Now, my lord, what they have done, since they were engaging such persons on contract basis whenever the government servant, deceased government servant died, my lord, subsequently they prepared a seniority list of the contract employee who were appointed on compassionate ground in 2016. And on the basis of the said seniority list, appointments on compassionate ground was given. Now, my lord, in 2023, they issued a paper publication saying that we are inviting application. And subsequently, my lord, they prepared a merit list on 8th of March 2024, whereby the incumbents who were junior to us, much junior to us, whose names are not there even in the seniority list of 2016, they were considered on and above us.
Are they in-service candidates or fresh
We
candidates?
all are on contract basis.
No, the ones who were chosen for
They are also on contract basis.
In service.
In service, on contract basis, but they were appointed after 2018-19. We are serving from 2003.
They've been placed above you.
About us. So, my lord, the consideration which has been made is absolutely, my lord, arbitrary, my lord.
What is the consideration made by the authority?
The consideration is not there. They say that there is a chart, they prepared a merit list, and on the basis of that, my lord, may kindly come to that paper publication, page 292, my lord. (292), my lord.
Yes.
Now, this they say, my lord, Director of Shipping Service, Andaman Nicobar Aviation Program is in the process of filling up under the scheme of compassionate. As per the instruction of the committee constituted for scrutiny of application under compassionate appointment, the detail obtained through the scrutiny of document has been in the tabular format while adhering to merit-based policy devices and implementing by the Ministry of Home Affairs. So here, my lord, even the OM is also wrong, my lord. That would be 2nd August 2020, my lord, which evaluate the economic condition of the family of the deceased medical retired government servant on a 100-point marking system. Adhering to the advice, 60 number of applicants received from the dependents of the deceased government servant were in the tabular form for determining the candidature for appointment under compassionate ground under the department against 16 number of vacant posts. In this regard, the merit table for appointment for compassionate ground is published for the interest of the candidate and general public within 15 days for claim and objection. Now, my lord, will get these names. My lord, their date of initial engagement on contract basis is not mentioned there. Now, my lord, they say this point. My lord, on the other day, when the matter was taken up before the tribunal, the private respondent, though he has not pleaded, when the court inquired him how he is entitled, then he said, my father died in 1993. And his case was considered in 2022 on contract basis after 30 years. And now he has been considered for regular appointment, and we have been appointed in the working since 2003. There is no clarity, my lord, from this document. Now, my lord, will find.
Did you file an objection to this merit list?
Yes, my lord. My lord, we have filed objection. We categorically said, if my lord may kindly come to the objection, my lord, page 293 onwards. My lord may kindly see the objections. I will just read the relevant portion of the objections, my lord. My lord may kindly see page 293.
Yes.
It says, this is to bring to my father, since my father's divorce, the group C category. Under the Director of Shipping Service, Andaman ground. In this regard, following the notification, so and so I have applied. My lord may kindly come to next page, my lord. However, the merit list was published on so and so, has been placed me in a highly disadvantageous and derived my right to get compensation and further pushing my seniority to rank number 35. This is despite my long wait of 20 years and past application for seeking compensation following the ultimate demise of my father. Therefore, I request you to kindly consider my application seeking appointment under compassionate ground, as I have been placed in the seniority and have an experience of so and so upon the so and so submitted my rightful employment ground and so without due process and recognized to the basis of application submitted in this regard. Now, my lord will find, I will show some of the representation where they categorically said these persons. My lord may kindly come to 295. Last second paragraph.
Yes.
It says, in view of the list of the candidates selected for regular appointment, to submit that the name selected serial 5, namely Lakshmi Kumari, is not entitled to compassionate ground, as his one son is a regular employee of Indian Air Force and another son is working in the Marine Department. More, she is having a room at Anarkali as well as more houses at Anarkali, and she given the house so and so. Last paragraph, that more the candidate selected in 32, namely M. Karmavati, age about 58, is not deserved to be appointed as her son is working as accountant in Indian Army Armed Force. Thereafter, my lord, next paragraph, further the candidate selected in 15, namely O. Asma Bibi, is not only married but also having her husband, is having handsome income and she is depending on her husband. My lord, at least 3, she has narrated 3 of the incumbents out of 16 who were selected. These are their background. So, my lord, likewise, my lord, all the applicants have said so, and they said you have to act in terms of the seniority list which was prepared by you. Now, my lord, may kindly see the seniority list, my lord. Page 244, my lord. Appointment order.
Yes.
My lord, may kindly see, this is a seniority list prepared. 44, my lord, this is of 2016. Many of the incumbents who were selected, their name even did not appear in this list, my lord. Now, my lord, may kindly see this paper with page number 253. My lord, these 5 names, my lord, will see these 5 names appear for serial number 1 to 5 of the seniority list.
Yes.
Now, my lord, may kindly see now, my lord, may kindly see the extension orders, page 142, my lord.
Yes.
Now, my lord will find that this is of 2007. The principal director of shipping service has been pleased to appoint the following compassionate ground applicants. Compassionate ground, my lord, I am harping upon this, on consolidated wages against the following vacant post on consolidated wages. Now, my lord, this appointment was on compassionate ground and that too against a vacant post. My lord will see the compassionate appointment scheme right from 1958 says, my lord, if there is a vacant post, you appoint them on regular basis. There is no question of appointing them on contract or on wages basis. So, my lord, this 142, my lord, can you see 150? I am showing some of the documents, my lord. Same thing, my lord. I am just showing this to compassionate ground against vacant post. Likewise, my lord, there are several orders, page 151, 153. Scheme can.
Do you want to use an affidavit in this?
No, already there was an affidavit.
But this is what the submission made before Lordship was not the fact before the tribunal. Because they have want that the scheme of 2nd August 2022 to be implemented.
Yes.
That is the prior. With regard to seniority part, this is not
No, arguments were, these were documents from the saying, yes, my lord, I will show from the facts were not written, my lord, in the impugned order so far as this case, because the lead matter was this one, my lord.
No, our question is, can we take up the matter for hearing without affidavits, or do you want to come back with affidavits?
But so far,
documentary.
yes, my lord, all the documents which were there, only one document I have incorporated in the writ petition. Since, my lord, the objection which I have filed before the authority during the pendency of the original application, they have rejected it by a cryptic order saying that we have acted in terms of the office memorandum. That I have incorporated in this. So,
chance diya jaye.
But so far as Milord will kindly come to the prior in portion, because they made a series of prior, not subsequently the tribunal told them to delete the subsequent priors. If not, it 424 is the prior portion now. But the only contention was that the scheme of second
Has to be implemented.
implemented. And if you not see the findings of the tribunal has categorically called for the records. The entire records has been called for because not this is a 100% marking system has to be adopted. The question of seniority is maintained by the department only to the extent that they want to give a compassionate appointment so that the person who has died, their family should not be live in a further livelihood. Survival of the livelihood, a compassionate has been given. It is a 5% quota, my lord. Whenever the vacancy arose, 5% quota has to be filled up among the compassionate.
We have compassion.
As the vacancy arose, 16 posts have been notified that this post will be filled by a compassionate quota. And based on compassionate quota, the applications, those who have been submitted already before the authorities, has to be scrutinized and the 100% marking system has to be adopted. That is the order which is issued by the government of India, that in order to maintain a transparency, so that a person who is really entitled to compassionate, he has to be considered, because a person who is having source of income more than what is required to be given, that person considered, because a person who is really for required to survive his family, he has to be considered. That's why not the 100% marking system has been provided. Based on 100% marking system, marks have been provided, and the final merit list, provisional merit list was published. Agreed with the claims of objections have been invited by the authorities. They have submitted claims of objection. We said we will follow things. Not the 2nd August 2022 and the 17 June 2022, because the marking, how it has to be done, and the procedures and the compassionate procedures which has been elaborated in 2nd August 2022.
So we can infer that you don't need to file an affidavit in opposition in this matter, right? You're ready for the hearing.
Yes, not because this is the only fact which has to be decided by the lordships. Well,
Yes, have you completed now?
No, my lord.
So are we on the hearing of
My
the
lord,
entire matter?
my lord, my lord,
Yes.
my lord, my lord. Now, my lord, may kindly see the scheme, my lord, once. My lord, may kindly have a note of it, my lord. We are working on contract basis, engaged on different point of time when the government servant died.
2003 to 13 you said.
13. My lord, kindly come to page 260, my lord. It starts from page 255, the scheme. इसमें देखो कौन-कौन सा पैटर्न reproduce किया
255, yes.
It's from 255, relevant would be 260. इसमें भी होगा कौन-कौन सा clause है
60, yes.
260. My lord, first I will show clause 7 and thereafter the other. Now, my lord may see determination available of vacancy. Appointment on compassionate ground should be made only on regular basis. And that too only if regular vacancy means for that purpose are available. So, my lord, the basic ingredient of this office memorandum is that whenever you are complying with this office memorandum, an incumbent ought to be appointed on regular basis. There is no nomenclature, ad hoc or contract or daily wages. So it ought to be on regular basis. So, my lord, this is the paramount consideration which, my lord, I invite my lord to kindly consider this aspect. Kindly see, clause, my lord, whatever I feel that it's relevant, my lord, I'm just placing it, my lord. My lord, page 259. It says compassionate appointment are exempted from execution of the following requirement. Recruitment procedures without the agency of the staff selection, so and so, clearance from the surplus cell of the Department of Personnel, the ban order on filling up issued by the ministry, so and so. Thereafter, subclause B says upper age limit could be relaxed whenever found to be necessary. The lower age limit, however, in no case be relaxed. So, my lord, these are the consideration. Now, my lord, may kindly come to clause 8. Page 262, my lord.
Yes.
It says belated request for compassionate appointment. Ministry department can consider request for compassionate appointment even whether the death or retirement on medical ground of a government servant took place long.
Clause 9.
My lord,
Clause 9.
clause 9A, my lord. 9A. 9, no? Even 8 and 6, so, my lord, the time limit for consideration application for compassionate appointment prescribed time limit for consideration of so and so has been reviewed subject to availability of vacancy and institution on the subject issued by the department and as amended from time to time. And 9 says ministry can consider request for compassionate appointment even where the death or retirement on medical ground of a government servant took place wrong way. So while considering such belated request, it should however be kept in view that the concept of compassionate appointments is largely related to need for immediate assistance to the family of a government servant in order to relieve it from economic distress. My lord, may kindly note this. This is the only consideration, my lord, why this compassionate appointment is to be made. Yes, my lord. Lord, my lord, may kindly come to page 264, my lord.
Yes.
Now, 264, clause 13, subclause 6, my lord. It says, some departments such as CBIC, Director of Posts, Director of Defense have devised their own point-based merit system for processing claim for compassionate appointment. In order to bring in transparency and objectivity in dealing with such claim, such a system may do so by devising their own point-based merit system for assessing the merit of the claim of the compassionate appointments. Pausing for a minute, my lord will find that the OM itself says the department has to create their own point-based merit system. Now, in this case, my lord may kindly visualize the situation. Persons are working from 20 years, 15 years, 10 years. So, my lord, they have to adopt a system whereby they can consider this factual aspect of the case and thereafter they can appoint an incumbent who is actually in requirement of this. My lord, today, my lord may kindly visualize 2003 I am working. Today it cannot be say I am in economic distress. Likewise, none of them, because all are working on contract basis. So, my lord, this scheme, they have any system, my lord. It is an admitted fact. They never said that we have developed a system. They say that in terms of this, there is an annexure B which says 100-point merit list. We acted in terms of that merit list.
This is a 2016 scheme, right?
No, the scheme is a compendium of all the scheme on 2nd August 2020. This is at page 255. It starts from 255. So, my lord, admittedly, my lord, let my learned friend show that they have created any system. Because the scheme itself says that, my lord, the system in using their base merit system. So they have not developed any system at all. They say that there is an annexure to this OM. We have acted in terms of the annexure 2. Now, my lord, in the facts and circumstance of the instant case, whether that can be worked, that will come into play when an incumbent died and he was not given any appointment on contract basis, and under such circumstances, on the basis of the said scheme, they can act.
Is this scheme for the existing employees or for new incumbents?
It is only for new incumbents. It is one, my lord, there is no nomenclature contract employee under this scheme, my lord. This is only on regular basis. So what my submission is, my lord, I say, my lord, first of all, this scheme, you cannot, my lord, you cannot apply it as per your convenience. If you are applying it, you have to apply in total. You cannot apply in such a manner that the earlier provision will become redundant. Now, my lord, the very concept is that it ought to be a fresh appointment on regular basis. Now, admittedly, you have engaged all these incumbents on contract basis on compassionate ground against a vacant post. And they are working from last 20 odd years. You prepared a merit list saying that this is the merit list of the compassionate appointment on contract basis. And on the basis of the said merit list, you have appointed 5% on the basis of seniority.
5% permanently.
Permanently, my lord. Because they were also working on contract basis. They prepared a seniority list of contract employee who were appointed on compassionate ground.
And the 5 senior-most
persons were given appointment in 2016. Now, I say, my lord, you have to act in terms of the said seniority list, or you form some modality based on the facts and circumstance of the case. You cannot, my lord, this in toto, my lord, since it is not a fresh appointment, therefore you cannot agree to this. You have to, if at all you are considering it, you have to prepare a modality. By what modality? On the facts and circumstances of the case. So, my lord, clause 7 and clause 13, subclause 6 and clause see,
Is there any scheme of the authority saying that the existing employees who are on contractual basis, they will be considered for this, under this scheme,
no,
or will be absorbed?
no, nothing, my lord.
Because these are two separate limbs.
Absolutely separate, my lord. Now they are saying we are complying this. If you are complying, that ought to be a fresh appointment on regular basis. My lord, in terms of,
Have you applied under this scheme?
yes, my lord.
Fresh?
Yes.
इसके कॉन्ट्रैक्ट की कंपैशन ग्राउंड में जो दिया है उसको रेगुलराइज मतलब वो हक रखता है और मेरा जो केस है वो माइनॉरिटी था मैं माइनर था मेरा फादर जब पहले हुआ इसलिए मेरे को लेट हुआ जो विनोद सर ने अभी कहा है वो ऑर्डर मैं आपको सबमिट करना चाहता हूँ
उनको कंप्लीट करने दीजिए हम लोग सुनेंगे आपको.
So, my lord, this ought to be a regular appointment. If you are adopting this, then you have to consider the fact of the case in terms of clause 13, subclause 6, which clearly says that you have to form your own system, how you are going to. Now, my lord, since we all are working from years together, my lord, what was the consideration? I have shown, my lord, 8 March order, wherefrom doesn't reflect that.
Now it cannot be financial distress.
It cannot be, my lord, absolutely not.
It is working already.
Yes, so the very purpose that would be in clause number 9, my lord. Clause number 9, it was categorically stated. I am just Senate appointment, page 262, is largely related for immediate stress. Page 262, my lord.
Yes.
9. So, my lord, this is the purpose why this scheme was promulgated. And when already these incumbents all are working, my lord, in such case, because, my lord, that's why before the tribunal, I have also made a prayer for regularization of their service. The tribunal said plural relief cannot be. And therefore, when the matter was heard and argument was concluded, before passing judgment, the court has, to be mentioned, the matter was listed and said you have to delete the prayer. The order is there, whereby I have deleted the prayer. The court said you are at liberty to file up.
It was a better prayer for you, I believe, isn't it?
That was a better prayer. The court said liberty was given that you can file application for regularization before the tribunal.
Have you filed such application?
No, this is only on 25th July this order was passed, my lord. 25th July, the order was passed, and 28th I have challenged it before this court.
Will you please come to the order of the tribunal and the authority?
Final order, my lord.
The final order, because if liberty was granted to you to seek regularization.
Yes, yes.
That was always a better option for you.
My lord, but at the same time, my lord, what I am on, the process which has been adopted by him, that has to go. How a junior who was appointed in 2020, 2021, they can sit over and above me when I am working from last 21 year. This is a clear.
That's why we would like to see the order. I think they consider this financial distress part.
Yes, my lord, not considered, my lord, nothing has been considered. I will, add to that, my lord, I will place that order whereby liberty was given. Page 339. नहीं कौन सा नहीं I am just a minute. 383 my lord कौन सा नहीं ये दूसरा आदमी का just a minute. Impugned order से पहले था ना.
383.
No, my lord, I am just placing it. Page number 418, my lord, just prior to the impugned order, my lord.
418, yes.
Yes, my lord. Learned counsel for the applicant had submitted they did not want to press the prayer A, 3, 4, and 5 with liberty to challenge the same in a separate. In the instant 3 would be plural reliefs. In view of the above, learned counsel was directed to delete the aforesaid prayer. Learned counsel for the place on record the file relating. Now, my lord, kindly see the impugned order. My lord, even the facts are not. Because this matter I have argued before the tribunal. This was the lead matter, my lord. My lord, may kindly come to.
Where is the application before the tribunal? The
Original
page?
application.
The previous page?
Yes, my lord. Original application, my lord. Yes. Prayer, my lord, or
The prayer.
prayer. Yes. That,
Retained and what has been deleted. Right?
my lord, I have quoted it in my writ petition.
I have also quoted it in the. Along with NBC page 24 of the petition.
Prayer A1 was considered.
Well, A1 and A2 was considered.
Three, 4, and 5 were deleted.
Page 480.
Yes.
Now, my lord, can you see the moving order?
Because they are prima facie interconnected. The first
But
two
can
prayers
they-
and the,
Because you cannot have more than one prayer.
even if you pay the additional court fees, you cannot.
No. The statute itself it is there, you cannot have total five prayer. Sometimes we take transfer or.
We find the prayers are interconnected actually.
On that day, even I was out of station.
Because since these three issues were not decided by the CAT, I don't think we can delve upon these issues. You have to file an OA before the CAT again.
So that is with regard to regularization, my. Now, so far as this scheme, my lord, under the garb of this scheme, the merit list which they are published, whether that can sustain or not, that is the subject matter, my lord. Yes, absolutely. Absolutely. Because that prior with regard with the regulation.
Method adopted in 2016.
No, 2023. Terms of the OM was adopted in terms of 2023. So, and that was availability of vacancies, whenever vacancies, they are the projects and they are.
And what happens to the candidates who are already there?
Yeah, but on contracts, not, and I said, because the difficulty is that because those who have been under the persons of mother, who are working was expired, in order to. Terminate the department on a good faith and given compassionate department on consideration. And a list of the compassionate.
Now, what is this good faith when it was beyond the scheme?
No, it is no scheme for compassionate alert. This is a 5% quota. Regular appointment has to be given.
That has to be under some scheme.
That's why, the compassionate appointment on contractual basis, not without any scheme, it was on a contractual basis.
How can a government authority appoint without a scheme?
Not
Even if it is on contractual basis, there has to be a scheme for that.
terms of.
Otherwise, the appointments are bad in law.
Right, but we have the appointment on contractual basis.
We understand.
Vacancy arose, we shortlisting and they give an appointment on regular basis. And based on the regular basis, this was the process that we initiated by the department. And the regular process in terms of the scheme.
How could you discriminate? Both are on compassionate ground, right? From 2003 to 13, you've appointed some people on compassionate ground.
So then the appointment itself is bad in law because I would say, because the 5% quota has to be maintained. Because for consideration, because for the livelihood, that's why I said.
The 5% quota out of the entire vacancy is on a regular basis.
On regular basis.
That was right from 2003 when these candidates also were taken.
regular vacancy not as compensate quota vacancy, not because we have been given to consider them.
You have just said that compassionate quota is 5% of the regular vacancy.
5% of the total vacancy.
So, yes, so 5% is compassionate quota. It has to be regular. There is no scheme for contractual employment, right? How did you employ these people on contractual basis in 2003? 3 to 13, in fact.
On the basis of the availability of vacancies, which is prevailing in the
Where is
department.
the scheme? Where is the rule? It's a government department.
Backdoor entry. Because they have been considered without any procedure.
Can there be a backdoor entry in the government
That has been done on
organization?
various occasions, because that's why the issue which has been there aiming for.
So if you have given a backdoor entry, you have to consider their regularization first.
That's different aspect, not this instant way, we would have filed a separate way for regulation, that is a different issue. But at this
Regular
only they are selling the compassionate appointment, the soft method adopted under the compassionate law. What are the procedures we have followed? That would be in terms of the law or not, in terms of the scheme or not. We say in terms of the existing scheme, we have prepared the merit list. But the government of India standing by issued the scheme, 2013, now 2022 scheme. Up to 2016, we are given 5%.
And so the earlier candidates, they remain contractual forever.
Not that is not the, what I say, they were in terms of this.
So isn't that discrimination? How can that be within the scheme? And if you have done it backdoor illegally, it's incumbent upon you to regularize.
The department has.
That's one reason, Mr. Binu, why I said that both the issues have to be taken up together contemporaneously. Because once you say that this scheme will not work, at the same time, there should be a ground for regularization.
That's my feelings, that was my ground below the privacy.
Whether this scheme is, whether this writ petition goes in your favor or against you, that will really not help. If we come to the practical aspect of it,
Then I have to not send an approve for regular.
you have to. If that is not done, then why will this scheme be unnecessarily set aside? If they are connected, I hope we are able to explain.
No, we are not asking the scheme to be set aside. We say that we have to follow this, we have initiated.
You have to follow the scheme and give you the seniority.
We have to maintain the seniority and they have to be considered based on the seniority.
And they say since you are contractual, they are regular, there cannot be any inter se seniority.
Point only, not I just landed, but I can not. The only aspect is their way was that if the government of India has notified a scheme, the self-marking system in June 2017. Subsequently, in 2020, a new scheme has come, which says that all compendium of all the schemes, they say you have to follow the procedure. This has to be done in terms of the filling of regular posts of compassionate appointment. Not this based on scheme, we have invited application, we have shortlisted on the basis of marking system. Because the emergency, they are given how the marking system has been provided. If a person is having landed property, what marks has to be given for that particular? If a person annual income is more than this, what has to be given? So there are given what the untracked marking system provided, so it has been given in the scheme itself. And based on that, we have done the marking system and we have notified that this is the based on the marking.
Then all that is fine, but what do you do? How do you deal with the employees who are already there with you?
That they are working under compassionate contract. This is not that they right. Suppose they go for a regulation or what are the claim, that is subsidy. But this instant way which they are racing for is that we have not followed the scheme. And they say that they himself their prayer was that in terms of second August 2020. Also in terms of this instant scheme, we say we have done after the scheme only as per your prayer. And the tribunal also observed in the order what the prayer which is given, which has been enumerated with this applicant.
Is already fulfilled by the department.
Prayer which they say as a 2nd August 2020 was being followed and I verified the record and the tribunal thought we have followed the scheme of 2nd August 2020. But there himself is saying that we have to follow the 2nd August 2022 scheme. You may not be kindly once come to that prayer.
That's the reason why we feel that if both the matters are not taken up side by side, then only following the scheme will really not help you, because this is a regular candidates, yours is contractual. You need to merge both. Basically what you're asking for is regularization of your contractual candidates upon maintaining their seniority since they're working from 2003. That is the crux. Yes, so that can be done only when a separate application is filed for this. Both needs to be dealt with together.
In that case, it may be subject to my lord. Can be demand back, my lord, if this, and may be allowed this prayer.
No, when you say that you cannot do that before the tribunal, and you have been given liberty. So before coming to this court, you ought to have filed a fresh OA and so that the tribunal can deal with it. Both these matters, if you are aggrieved by that also, then both these matters need to be taken up by this court together. Because taking up only this matter will not help. So now it is for you to decide. We can of course take up this matter, but I don't think it will really inure to your benefit.
In that case, I not all along I enjoy the free model. Like that, the retained model in the meanwhile, I will file an application.
What is the, what was the interim order?
Not to affect to this man. Simply manner in the, that is, actually number. Page 323 number. And the original application was pending, they were pursuing further for giving appointments. So we have taken an application, miscellaneous application before the tribunal. This is an order dated from the 2nd of July 2024.
Yes.
Now, my lord, one last paragraph, at this stage, the learned counsel. My lord, we kindly come to page 324, last paragraph. The court said, my lord, it is expected that the respondent will not create any right of fact, particularly the matter is taken up for final hearing or so and so prove adjournment. And thereafter it was extended from time to time. And therefore they did not able to pursue further.
Let us hear the private respondent what he is. हाँ बोलिए.
ऑर्डर इसमें मेरा जो सर ने बताया कि बहुत देश बाहर रहता है तो रीजन इसमें इंक्लूड लेट क्यों में माइनस ओपन कोड इसको अलाउ किया है के लिए मेरा नाम इलिस्ट्रेट हुआ और जो भी अभी लिस्ट बना है तो प्रेजेंटली तो इकोनॉमिक कंडीशन इसका कोई है उसके हिसाब से ये लिस्ट बना तो
There should be some, ऐसा कोई स्कीम है क्या? इकोनॉमिकली जो ज्यादा वीकर सेक्शन है उनको पहले किया जाएगा. तो सेट अप दिस बट the direction was to devise some mechanism.
That mechanism has not been, that's not in place.
The mechanism how to adapt that is of scheme.
Does that deal with the employees who are already on,
Everybody, not
already,
not that is not there. On contract basis who are working, not like by like. That contract aspect is a different thing. I will say, not me kindly, not I.
that's why we wanted to see the scheme under which they were appointed on contractual basis. Because they cannot be made to suffer. You suddenly come up with a scheme talking about regular appointment.
Different aspect because we have on that's why I said not on a good faith we have been given.
Can there be anything called good faith in government organization?
Because we could have not given.
You like some people, good faith. You call them and say, come on, join.
But I would say not the persons who have been want for the family for survival.
There must have been some scheme in some place.
In the government organization, he says it's backdoor appointment.
Not that, so that is a.
And there is nothing to show that there was some scheme for appointment under on contractual basis.
This is I say not. Attached appointment with 5% quotas. Not I just see not 2005.
Does compassionate appointment allow contractual appointment?
That is contractual or compassionate appointment cannot allow contracts. It should be on basis of 5%.
So you have gone wrong from day one.
We have even, all the persons, not here 5% quota is not there. All the persons, the availability vacancy of the department, because we have to give salary under any other vacancy. So all the persons who are in the list, everybody is working, and they are not under the correct 5%. If we shortlist 5%, then the as per the available vacancy 5% has to be considered. It may not putting a question on that aspect.
After more than 10 years? After more than 10 years?
But they are working, that's why I'm saying, not on basically 5% quota. We have been given all the purpose of after the death of the demise of the government servant.
How do you discriminate, sir? This is a government organization.
Not, the quota has to be maintained, 5% quota we have to.
That you did not maintain initially.
Not initially also when the vacancy arose, that's what I'm saying, not from 5 to 2022. we have
So
been-
when the vacancy arose, you ought to have regularized the candidates right from 2003 onwards according to their seniority.
Not we have given, not that's what I'm saying, not prior to 2013, the scenario is different. After 2013, the government of India, when an OM has been introduced, which is to be followed, and the self-marking system has been introduced. But that's why I want to differentiate. Not 2005 scheme, 2013 scheme, now 2022 scheme. These are the different three schemes which has been come based on the government of India. You cannot say 2005 scheme is altogether different. We have to give 5% on the basis of seniority we are given. So up to 2016, the appointments have been given. That's not issue. When the 2022 scheme has come in, right? When the availability of vacancy we have to follow the existing scheme. What is the existing scheme is the 2002 scheme. And as per that, we have given the self-parking system has to be introduced. So that there cannot be any discrepancy in transparency has to be maintained. Self-parking system introduced. They say the self-parking system should not be introduced. And they himself is saying that we have to follow the compendium of 2nd August 2022. We have followed the compendium of 2nd August 2022. Let them show that we have not followed. That is the only question. Not because the tribunal also, the tribunal has based on that adjudication, the tribunal formed the records. Whether under the marking system we have done any persons to be favored or not. Based on the entire records of the 60 persons who have been approached and they have been shortlisted and they have found that it was correct. As such, the tribunal has found the scheme of 2nd August 2022 and the self-marking system under 17 June 2020 has been followed. You know, I understand whether the contract actual altogether is different. They can have a right to go for regulation if they continue working with the series of judgments of this honorable and the Supreme Court also. But at this instant case, they are only challenging the procedures, the methods which are adopted by the authorities, shortlisting the compassionate 5% quota which is available subsequently after the scheme.
Primarily, their issue is without taking care of the contractual appointees.
The 2002 scheme, when the vacancy arose after 2002, 2000 scheme is in existence. That 5% quota we are fulfilling. The 5% quota we reserved it for this compassionate, and we are shortlisting based on the 5%. That is the difficulty.
What we feel is it will be better for you to approach the on. Is he able to follow what they are saying? The councils are saying.
आपको समझ में आया उन्होंने जो क्या कहा था? उन्होंने क्या कहा?
सबमिशंस हो रहा है यहाँ पर आपको समझ में आ रहा है ना ये सबमिशंस? हाँ.
और अभी जो रिसेंट ऑर्डर कैट का है आपके सामने है उसको पढ़ने के लिए
He is placing certain circulars also, so I think he needs to come back with an affidavit.
Yes, filed an affidavit before the trial.
Before this court.
Before tribunal, yes, filed.
आप एफिडेविट फाइल करना चाहते हैं इस कोर्ट में ये डॉक्यूमेंट्स एनेक्स करके?
आता नहीं है तो ओके हायर किया था इतना पैसा मांगा गया था
स्टेट लीगल सर्विस के कर दो
आपको चाहिए लॉयर चाहिए
लीगल सर्विस हाँ स्टेट लीगल सर्विसेज अथॉरिटी जो है यहाँ पर गवर्नमेंट एक्सपेंस में आपको लॉयर मिल सकता है हाँ so let him come back with this in the meantime you are having some breathing time so you can file and I don't think an interim order is required because
Tomorrow they can fine.
So 16% on the basis of the.
I'll
That's why all along there was an entry model. But
मैडम एक प्रॉब्लम ये भी है जो लिस्ट बना हुआ अभी मैं ये ऑर्डर कैट का ऑर्डर बने के बाद डिपार्टमेंट में गया था
हाँ,
तो उनको मैं पूछा कि
इस लिस्ट में आपका नाम भी है ना? हाँ, हाँ,
सोलह जन को लेना था तो मेरा 10 नंबर में मेरा नाम आया तो मैं इसीलिए मैं कोर्ट में गया था कि उन लोगों ने एप्लीकेशन किया था कि ठीक नहीं है तो रिजेक्ट कर दो क्योंकि मेरा फाइनेंशियल कंडीशन बहुत खराब है तो उसके बाद मैं जब इंट्री सॉरी कोर्ट ऑर्डर आया था कैट का उसके बाद मैं ऑफिस में गया बोलते कि अभी भी होगी मतलब प्रोविजनल लिस्ट बता रहा है लेकिन उसमें कैट में मेंशन किया है कुछ गलती नहीं है फिर भी प्रोविजनल बता रहा है तो मेरे को ये समझ नहीं आ रहा है कि मेरे साथ क्या हो इसमें बोला ये कैट का ऑर्डर में
this is a little complicated matter. I think he needs to be assisted by a learned counsel. For him alone, it will not be possible.
इसमें कहा गया है 7 नंबर पॉइंट में जो कैट का भी
Order है, हाँ।
डीआरएफ का मेंशन किया था जो डीआरएफ कॉन्ट्रैक्ट बेसिस दोनों अलग अलग चीज है मेरे को जितना पता है और डीआरएफ का कोई बेसिस हम लोग का अभी तक नहीं है फ्यूचर अपॉइंटमेंट डीए दिया जाता है ये नहीं जाएगा
For meager salary, these persons are working from last.
I understand. We understand. Mr. Kumar, I'll request you not that the authority doesn't take any steps in the meantime.
And tomorrow my letter friend, instead of my letter friend, some other advocate will appear. Can we? Can we? There are two aspects. One,
What is the relief which is in tribunal? They say that we have to follow. Again, I'm repeating, my lord, I'm sorry, my lord, I'm disturbing this honorable court. But my lord, 2nd August 2020, we have to follow. My lord, we kindly see once the tribunal's order, what the tribunal has passed an order.
Direction.
My lord, may kindly come to this.
Tribunal dismiss the original application.
My lord, may kindly, under what pretext the tribunal is dismissed. My lord, I just read the operative part. My lord, is para 9. Para 9 of the tribunal's order. My lord. Page 433. My lord.
Yes.
It is observed that the applicant has applied against the press note 27th March 2023, wherein the Director of Shipping Services, Andaman Nicobar Administration, Port Blair, had asked to submit application for compassionate appointment with the documents as stipulated in the said note within 20 days from the eligible dependent family members of the government servant. The applicants applied for the same and the committee constituted for consideration of the compassionate appointment as per the Office Memorandum 17 June 2022 as well as 2nd August 2022. The Master Circular 14, as per clause 14, Roman 11 of the Master Circular dated 2nd August 2022 and the respondents following the procedures and terms and conditions of OM dated 2nd August 2022 and 7th June 2022. Since applicant themselves consideration of under OM 2nd, in our considered opinion, the respondent has admittedly considered the case of all 60 persons, including the applicants, on the basis of their merits on the point-based merit system and had published the merit list. We do not find any reason to interfere with the decision of the respondents as they have already applied 2nd August 2022 and OM 17 June 2020 is the only point system based on merits as per the Master Circular 27 August 2022. The applicant had applied against the press note. They cannot now turn and around challenge the same as a later point out. Moreover, it is a fact that the applicants are much lower in the merit than the private and this OA lacks merits. Lord, they want it to be 2nd August. That's why the tribunal, after verification of records and after giving opportunity of hearing, the tribunal come to a finding that you himself is saying it has to be followed. We found that it is followed. And at this time, they cannot pray for an entry model, not because they want this.
The 2nd August memo has nothing to do with you, isn't
Well,
it?
well,
It has nothing to do
Well,
with you. So whether this is there or not is a
my
different.
lord, it's a case of discrimination, my lord. A
Well,
person
that was
working
the
from
point of
2003
regulation, my lord, but not as the
2003.
compassionate.
Discrimination, my lord.
This deals with regular.
Regulation, but
That has
not as
been done according to the
tribunal.
scheme, the points based.
That ought to be a fresh appointment, my lord. That ought to be a fresh appointment.
These are fresh appointments under
No,
the
no,
scheme.
yes, fresh appointment, but the incumbents are already working. The merit base which you have prepared was pertaining to the persons who are working on contract basis under you. So how you can discriminate the persons? Admittedly, all of them are working under you.
So that has not been taken into consideration
That
at all.
has not at all
in
been
this.
taken into
So
consideration.
that is a different cause of
Cause of
action,
action,
sir, I
my
should
lord.
say. Because
My lord, may kindly consider.
adhering to this scheme or not doesn't really affect your case.
No, it will affect
You
me,
need
Lord,
to
because
get into the scheme.
my lord,
Yes, yes.
no, my lord,
Himself,
we are in the merit at the top.
The scheme is with regard to regular
Regular
candidates
appointment, but regular appointment of not the fresh employees.
in
It is,
terms of the vacancy as after the scheme.
but these incumbents, all these incumbents are working on contract basis. When the persons are working on contract basis, those who are working from 2003 and those who were appointed in 2020, whether those persons can be given appointment on
That
the.
is clear to us now.
Yes.
That is clear. What you
It cannot be,
asking
my
for
lord.
is clear to us.
Yes.
But was that prayer there here that in before the
We have asked for
Strike
caution,
it.
my lord. We have asked for caution of the entire proceeding which has been adopted by them. My lord, may kindly see.
they asked for quashing and they want us to follow the OM of
We
2020.
asked them to that system, my lord, may kindly see. They have to promulgate a system, my lord, which is,
That's the system
that
is
is what.
already available.
that
My
that is not.
lord, may kindly comes page number 348.
My lord, I am just
That
placing
is system.
13.6, my lord, may kindly see.
The system, what system it is there, my lord? 348, it is clearly given, my lord. How the marks has to be given, under what are the criteria has to be
My
taken.
lord,
into
may kindly
consideration.
see page number 264, my lord. Today, if the junior is appointed, my lord, definitely my right is affected.
Lord, this is
My lord, page Roman 6.
yes.
Roman 6 case, some departments such as so and so have devised their own point-wise merit for processing claim for compassionate appointment.
They have also devised
Yes.
a point-based
That
merit.
is
They given the point based merit.
Not at all. They say, my lord, in order to bring in transparency and objective in dealing with such, all ministry departments who have not developed such a system may do so by devising their own point-wise merit system.
Yes.
This they have not done. They have taken annexure 2 of the said office. Annexure 2 of the said office as a point to consider the merit, which cannot be on the facts and circumstance of the case. I say when already those persons are working, you have to adopt a device taking into consideration the facts and circumstances of the case. Then
Challenge the scheme. Is to challenge the scheme, saying that it is not that.
there is no merit in the scheme. Clause C,
He says it is not considered. He says you want to follow the scheme.
my lord, my
Now he
learned
cannot say.
looking incorrect submission. Why I am
Why
saying?
should I say incorrect submission? Go ahead. Page number 348. 348, my lord, once. 348. It is there, my lord, what is the marking system has been given, how the criteria has to be adopted. We followed this. That is the Government of India's notification. They agreed, they're saying this scheme, this is not to be an
Where
appropriate.
is your point-based merit?
No, they kindly 348.
My lord, once come to
348.
paragraph H, argument which I have made, lord, may kindly come to 328, paragraph number H, the affidavit in reply filed by them. My lord, may kindly see your opinion state that the committee based on the so and so whereby and whereunder the policy and guideline was prescribed for assessment of MHA 100 point under annexure 1 relative merit point system for allocation of point for various attributed of applicant for compassionate appointment in MHA based on 100 point scale for part C of annexure 2. The applications was assessed. So, my lord, the assessment was made on the basis of annexure 2 of the office memorandum. Clause 6, you have to adopt your own device.
We are central government. We are come under the purview of
The
this.
facts and circumstance which are prevailing in a particular state or particular region ought to be taken into consideration. That's why the government in the office memorandum has said so. They themselves admit in their opposition that they have taken the annexure 2 of the office memorandum.
Yes.
This is what I argued before the tribunal, that they did not adopt a system considering the facts and circumstance of the case. This is what
They have adopted the
Yes.
existing.
that was not the para 6 says, 13.6 clearly says they have to have their own device. Page number 266, my lord. 264. All ministry department. Got it, my lord?
Yes, to develop a system.
Yes, to develop a system.
But there is nothing wrong in taking,
Yes.
borrowing it from the existing system.
No,
There
no.
was an existing
Why
system.
they are saying to develop a system, my lord, here why I am harping upon this, because the facts and circumstances such, all the persons are working on compassionate ground on contract basis against a vacant post. So when you are framing a procedure, then you have to consider this factual aspect. That's why this domain was given to the authority to consider it. They have simply adopted the same.
Since your application is not in place till now, the regularization application, you can seek for interim relief before the tribunal.
My lord, may kindly, my lord, if this appointment
There
is.
is no reason for staying this
No,
at
no,
the moment,
if-
because you have not filed any application as yet. File an application and seek interim relief
No,
before the
my lord, may
tribunal.
kindly consider all.
It is done on virtual mode also
No,
now,
no,
yes,
no,
right?
my lord,
Yes.
all along there was an interim order, my lord, which was prevailing.
Maybe,
during the
but
term.
that is no longer
No,
there.
that is no longer, why, because, my lord.
And the application has been disposed of.
No, that has been disposed of, but that has been passed for a reason, my lord. I say, my lord, what protection I am seeking, my lord, let it be, my lord, for a limited period, my lord.
Not in the, I'm afraid,
My
I
lord.
don't think we can give it.
My lord, may kindly consider this. Tomorrow, if appointment is given, my application will become.
That is a different course of action he has, my lord.
You can file your application tomorrow and seek interim relief in
No, no, my
that
lord,
case.
interim relief, there what interim relief I can seek? I cannot seek stay of this, my lord. Because this is the subject matter of this application.
No, if your interim, if your other application is connected to this, you can seek stay of implementation of this, unless your regularization is
I
considered.
am before my lord.
No,
if
no.
Judicial.
Because your application is not in place.
Yes, yes.
No, my lord may kindly consider this aspect, my
On
lord.
what ground should I stay this?
Yes, my lord,
On
I say-
the ground that you have the liberty to file an
No,
application, no, cannot be
My
done.
lord, on the ground that this is a clear case of discrimination, whereby the incumbent who are working from 2003 has been
That is
left
not
out.
your prayer at all,
Yes,
sir, in
ma'am.
this application.
मतलब already.
My lord, it is there, my lord.
आप regulation के phase की application करे, फिर हम लोग का application क्यों करते हैं?
I'll allow him to be represented by a learned counsel from the SLSA.
My lord, may
Let us
kindly
fix
consider-
this before the next circuit. In the meantime, please have your
No,
remedies.
my lord may kindly,
Please.
otherwise, my lord may fix this day after tomorrow. I will file a petition before
If
the
you have
tribunal and.
petition there, you have to file interim relief prayer there itself,
My lord, kindly.
as you have
consider-
done in this application.
No, my lord may kindly consider, my lord, all along there was an interim order. Why I am
Sure.
saying this is a case of discrimination, my lord.
It's a different
Tomorrow,
situation
suppose,
altogether.
my lord, tomorrow suppose 16 persons were appointed who were much below me. Then what will?
Your discrimination prayer is not there at all here.
No, my lord, but we have categorically seek for setting aside of the said entire episode adopted by them. Our first prayer is.
On one hand, you ask for setting aside
Yes.
the scheme, and then you
Yeah,
and on
want
the
to
other hand, you
implement
ask
that
for
scheme.
compliance of the scheme.
That scheme.
I am not asking for compliance. I say that the clause 13, clause 6 ought to be followed.
Yes,
is
yes, so
followed.
that you're not challenging the scheme in that
Yes,
case. You
they're
say that
accepting
the
the
scheme is
scheme.
not being followed.
No,
Right.
only that provision, my lord, because the
13
scheme says
Your
regular appointment.
primary prayer is the 13.6 is not being followed.
Yes.
So if they say that we have borrowed this, whatever is called.
The
this,
self-marking system from the scheme.
Point-based merit system from all what was existing already, there's nothing wrong in it. There is nothing wrong in it. Only
my lord,
thing is your regularization. That is the issue.
No, but
The
my lord,
discrimination.
those incumbents who are
What
below me.
happens, yes, what happens to the persons who are already in service since 2003?
No, but at the same time, those who were appointed after 2018, if they are allowed to march on and above me, my lord.
मैडम तब
Lord,
से उन
kindly
लोगों ने
which-
मतलब कोई application भी नहीं डाला
No, the person is financially strong, my lord.
May kindly
The
consider this
compassionate-
aspect, my lord.
No, Supreme Court also deprecated this
They are
concept.
financially strong because they are working since 2003.
Lord, everybody is working,
Now.
everybody is working.
My lord,
That's why
kindly
we
consider
find
this.
the
My lord,
system.
for
Not
limited
not
period,
particularly this applicant, even the.
My lord,
Stay
consider
is
this. my lord.
required. I'll record your submission that you want to approach the tribunal.
My lord, may
seeking
kindly
regularization.
consider this, my lord. Heaven will not fall, my lord, because from last
No, my lord.
more than
But
2
there
years.
could be a ground for stay. There is
My lord, I am
ground
saying that,
stage.
my lord, I am saying that we have shot for cancellation of the merit list, which was published on 8 March 2025. Now, my lord, if in between the merit list, they are allowed to pursue further with the merit list. In that case, my lord, my writ application itself become infractuous, my lord.
I don't think it becomes infractuous.
No, my lord,
Because-
once appointment is given, thereafter what left in this writ petition? my lord?
Appointment takes a long time, sir.
No, my lord, already merit list is prepared by them.
Yes, after that, the appointment letter, the verification, the medical, you have sufficient breathing time.
My lord, may kindly
They
stay
are
for a limited
government
period.
organization appointments,
My
right?
lord, may kindly stay for a
I
limited
don't
period, my
think
lord.
it will be possible in this court. We'll have the liberty to ask for an interim relief before the tribunal. Let me record that. Huh? The petitioners, how many of them are there? One.
7.
14, my lord.
Oh, sorry. 14. my lord.
Have assailed the order passed by the Central Administrative Tribunal sitting in circuit at Port Blair on 25th July 2025. Dismissing the original application filed by them and you had also applied under this
Yes, yes, he also applied.
My lord, they have asked for application and thereafter they prepared a merit.
that was on the basis of your application also.
Yes.
You were part of it.
Yes.
My lord.
It's not
Oh.
that because you were already employed, you did not apply. It's not that.
No, my
You
lord.
have made a fresh application.
Yes,
in
all
terms
of them,
the
all
scheme.
of them has asked to submit an application, all those who are working on compassionate.
What did I say?
So therefore, my lord, the consideration was made and our case was negated. So there is no reason, this is a clear case of discrimination.
Stop. The petitioners were appointed on compassionate ground
Against vacant post, my lord.
against existing vacancies from 2003 for the make it for the period 2003 to 2013. Stop. A press release was published on 27th March 2023, whereby applicants, including the in-service applicants, within bracket the petitioners, were directed to submit applications for compassionate appointment with supporting documents. The petitioners applied for the same and were considered for compassionate appointment in terms of Office Memorandum dated 17th June 2022 and 2nd August 2022. The primary grievance of the petitioners is that the authority, in considering the applications of 60 incumbents, including the petitioners, has published a merit list of 16 candidates.
No, merit list was published. my lord.
Entire 60.
Entire 60. Yeah.
Disclosing the merit position of entire 16 candidates.
Has published a merit list on points-based merit system. 16 candidates were selected for appointment.
Not selected. We have only published the provisional list.
That is the matter, madam.
They have approached straight away challenging that provision.
16 candidates being appointed.
No, it's not. As per the merit, 16 persons will be point based.
Vacancies are 16.
16. Lord may write it as a provisional merit list was published.
Provisional merit list. Huh? Stop. The petitioners. No, not regularization. Fresh candidates.
As per the 5% total.
They applied afresh. And it was that many things. No, no, they are figuring in the 60 list. They are figuring in the 60 candidates, right?
Yes, yes, entire 60. All are, those are.
The petitioners say that the first 16 candidates in the merit list are candidates who are below the petitioners in seniority and they are also in-service candidates.
Yes, yes, they're also.
And joined service much later than the petitioners.
Even their name doesn't figure in 2016.
So there is no fresh candidate in
No, my
this
lord.
60.
No, my lord.
Everybody
list.
has.
Everybody are working under the earth. And their name doesn't reflect in even in the seniority list of 2016.
The names of these the first 16 candidates also did not figure in the seniority list of 2016. Paragraph, learned counsel for the petitioner has taken this court to this is 13.6, right?
My lord. First 7, my lord, regular appointment, thereafter 13.
To point number 7 of the scheme for compassionate appointment dated 2nd of 2022, which envisages that appointment on compassionate grounds should be made only on regular basis, and that too only if regular vacancies meant for the purpose are available. Learned counsel has referred to 13 Roman 6 within bracket of the scheme, which says that the departments should devise their own point-based merit scheme for processing claims for compassionate appointment in order to bring transparency and objectivity in dealing with such claims. Stop. According to learned counsel, such merit system has not been adopted by the authorities. The petitioners primarily seek regularization in service upon consideration of their seniority, since they have been working from 2003 onwards. Paragraph. Opposing the prayer, learned counsel for the official respondents submits that that the provisional list has been published in terms of the scheme dated 2nd August 2022, and the point-based merit system has been adopted from
17/6/2020. So the OM 17/6/2020.
adopted from OM dated 17 June.
17
June 2022. Learned counsel submits that the petitioners have claimed appointment in terms of the scheme dated 2nd August 2022, and it has been held by the tribunal that the appointment is in fact in terms of the said scheme. Paragraph, learned counsel for the private respondent explains the delay in his applying for compassionate, in his applying for appointment on compassionate ground to the effect that he was a minor when the employee / your father, his father expired, and upon attaining majority, the application was filed. That is your case, right? This is not learned concept. The private respondent appearing in person.
পড়াশোনাটা শেষ করার পরেও মানে মেজরিটি পড়াশোনা শেষ হলে তারপর অ্যাপ্লিকেশনটা করে।
He was also a student when his father expired.
No, minor. After
Minor, you've said. Minor বলেছেন আপনি।
No.
Just strikes. He was also from strike. The respondent submits that he requires the assistance of a learned counsel by way of legal aid to represent him in the present matter, right?
আমার একটা জিনিস জানার ছিল, এখন যে 16 জনের নামটা হয়েছে এটা কি এখন আর দেওয়া হবে না, এটা আবার আটকে দেওয়া হবে?
না, আটকে দেওয়া হবে না, ওনারা ইমিডিয়েটলি আরেকটা ওয়ে ফাইল করবেন।
তো আমি তো 16 জনের মধ্যে আছি, তাহলে আমার এখানে প্রাইভেট রেসপন্ডেন্ট হিসেবে আমার দরকার নেই, আমার 16 জনের মধ্যে আমি আছি। বুঝতে পারছি আমি কি বলতে চাইছি? আমি বলছি আমি 16 জনের মধ্যে আছি।
হ্যাঁ,
তো আমাকে
যদি
কি
এটা
দিয়ে দাও?
যদি অ্যাপয়েন্টমেন্ট দেওয়া না হয় তাহলে আপনার রাইটটা এফেক্ট করবে, তো সেই জন্য আপনাকে এখানে রাখা হয়েছে, পার্টি করা হয়েছে।
কি বলে আমাকে তো এনগেজ হতে হবে, আমাকে তো মানে ছুটিও পাওয়া যায় না, কন্ট্রাক্ট হিসেবে লেগে যায়, তারপর করবো আমি কিছু বুঝতে পারি না। তাই জন্য আমি একজন অ্যাডভোকেটকে নিজে দিয়ে করে
আপনাকে সরকারের পক্ষ থেকে অ্যাডভোকেট দেওয়া হবে। তাহলে কি আপনি চাইছেন না অ্যাডভোকেট? আপনি কি চাইছেন বলুন? ইন পার্সন করবেন। প্লিজ ট্রাই কর দিস ওয়ার্ডস। That submission of appointment. Only record his submission, okay? Till that minority submission, that will be there when he was a minor. Paragraph. It appears that before the tribunal, the petitioners, besides seeking recalling of the paper publication dated 8th March 2024, which prayers were delivered? Third is also to promulgate the scheme. Third is promulgation of the scheme. So oh, 19/12/22 is for regularization. What did I say? Also sought promulgation of a scheme in terms of the order dated 19th December 2022, passed in MA 09 of 2020 by this court. And for continuation of the service of the petitioners till such scheme was promulgated for regularizing the service of the petitioners. Stop. The second and third prayers stated above were not pressed by the petitioners before the tribunal. Stop. The petitioners were granted liberty to make such prayers in a separate application in order to avoid seeking plural remedies in a single application before the tribunal. No.
Different person first, our application was, he has not filed.
তো আমি চাইছি যে এখন যে মিলিটারি তৈরি হয়েছে সেটা ফাইনালাইজ করার টাইম দিয়ে দেওয়া
এই অ্যাপ্লিকেশনে সেটা করা যাবে না, আপনি এখানে পিটিশনার নন। এটা তো আপনার অ্যাপ্লিকেশন নয়।
তো আসেন
উনিও পিটিশনার নন, উনি রেসপন্ডেন্ট, আপনি এক্ষুনি বললেন উনি রেসপন্ডেন্ট। আপনার যেটা হয়ে আছে সেটাই চ্যালেঞ্জ হচ্ছে কোর্টে। হ্যাঁ, অন্যদের রেগুলারাইজেশনের জন্য ওটা সিনিয়রিটিটা ঠিক নেই, এই সব ইস্যুতে চ্যালেঞ্জ হচ্ছে। তো ওনারা আরেকটা ফ্রেশ ওয়ে ফাইল করবেন ট্রাইব্যুনালের কাছে, আপনি সেখানে প্লিজ ইমপ্লিড হিম অ্যাজ আ পার্টি সো দ্যাট হি ক্যান বি present before the tribunal. Please implead him as a party because he'll be affected with the order of the tribunal, right? In view of the above, comma, liberty is granted to the petitioners to file an application before the tribunal in terms of prayers
For regularization.
only for for regularization of their appointment. Yes. Upon such application being filed, comma, the petitioners shall be at liberty to seek interim relief for stay of the order impugned in the present application before the tribunal.
What is the here I am telling it's like a and both are fine.
The order impugned is this, you're asking for stay of this order, right?
But whose order and we very this one, we part. If not a city.
Please repeat that.
About the.
For stay of the provisional merit list published by the authority. সেটা নেই, স্টেটা নেই এখন আর। Paragraph, let it, shall I dispose it? Let it appear before the next circuit. Let the matter appear before the next available circuit. I have not made it, very well. It is made clear that we have not dealt with the matter on merits, and the learned tribunal shall be at liberty to deal with the issue independently without being influenced by any observation which may have been made in this order. Next.
The engagement was made. From 2015 to 18, I am just.
This is by another applicant.
There are here number of 16, there are 14 and here there are 7 applicants. I don't, they really engaged. They were engaged in 2015 and 18.
15 and 18. Instead of in between 2003 and 13 in the earlier matter, it will be in 2015 and 2018.
3 applicants are.
The remaining part will be the same. That's fine. Next.
Item number 4.
My lord, in item number 4, there is my lord, the Union of India is a necessary party because here, my lord, the administration has taken a stand, which is at variance with the recommendation of the UPSC. So, my lord, may grant us liberty to, my lord, serve the state respondents and, my lord, come back in the next circuit.
Have you implemented the Union of India?
Yes, my lord.
So you need to serve all of them, right?
Yes.
Yes, you also.
You're for the private respondent.
Private respondent possibly has been served, which is why he's appearing. but
He's appearing.
we have to serve the union of the other state respondents, and my lord may grant us.
The petitioners are directed to serve copy of the application along with annexure thereto upon respondent numbers. Both are
Yes, 4 and 5, I think.
2 and 3, both are
Yeah.
Union of India.
Yes, 2 and 3.
Respondent in this matter.
No, not unit, 2 and 3 is a UPSC. my lord.
UPSC,
UPSC and
Union Public Service Commission, that is independent. So we have to serve both of them.
Very well. Respondent numbers 2 and 3. And file affidavit of service on adjourned date. Paragraph, the matter be placed before the next available certificate. Next,
Same, my lord. 5 is similar, my lord.
2 and 3.
My lord.
In this matter
Yes.
also. Same.
Most grateful.
Item number 6, WPCT 16 of 2025.
My lord, I am appearing for the petitioner. Yes.
Not the.
Yes.
Is
My
there-
lords, I am appearing for the respondent in this matter.
Now they are serving.
What is this?
My lord, in terms of the earliest order, we have to file an affidavit.
Opposition?
No, my lord, we have to disclose the positions of the vacancy position. So we have enclosed it, my lord, in this in compliance with the earlier.
Oh, there was a direction for affidavits in this.
Direction was, my lord, to give an affidavit to explain the nature of duties, my lord, of the public relation officer during a particular period.
Yes.
So, my lord, that affidavit has now been filed. If they want to file a response to it, or I don't know what Mr. Kumar intends to do, depending on that.
My lord, if it comes to my lord, let it be on Thursday in the meanwhile.
Thursday, big matters cannot be taken
Well-
up. You must understand. Affidavit used by the respondents is taken on record. Paragraph on prayer of the petitioner, liberty, liberty is granted to use a reply to the said affidavit. Paragraph, the matter is be placed before the next available.
My lord.
Next.
Item WPCT 17 of 2025.
My lord, I am appearing for the petitioner. My lord, on the other day, my lord, one matter my lord has already disposed by judgment dated 1st of August 2025. The issue is, my lord, his petitioner was engaged in the year 1985. Subsequently, his service was regularized from 15th March 1993. And he became eligible to get the benefit of ACP on 15th of March 2005. Thereafter, MSCP scheme came, my lord, and he was entitled to get the second MSCP by 15th of March 2013. Now, my lord, first ACP was given to him at rupees 4500,7000, and his demand is 5,000, 8,000. And the second MSCP was given to him 9300, 3480, 4200, my lord, whereas I demand for 4600. Now, my lord, the demand is, my lord, on the basis that this petitioner has studied up to 11th class and is holding a diploma of 2 years. That is not diploma, Industrial Training Institute, ITI certificate. My lord. Our contention is that similarly circumstances persons got the said benefit. So I am also entitled to get this. My lord, there were several rounds of litigations, my lord, before this court, my lord, before the tribunal and this court, my lord. Now, my lord, I filed a supplementary affidavit. If my lord comes to page number 88. The authorities has negated my claim, my lord, and I filed a supplementary affidavit.
Page number 80.
88, my lord.
This was before the tribunal.
This was before the tribunal. Now, my lord, I say that if my lord comes to, my lord has already rendered
lord
the
has-
judgment.
Lord, if you remembers that with regard to the chargeman,
Yes.
yes, my lord has heard. Not this person is not at any point of time promoted to the post of chargeman. My lord has specifically passed an order that a person who is promoted to the post of chargeman.
I do not
In-
find it's a similar issue.
Yes, sir.
It should maybe.
Can be decided without affidavits?
Go through the records because this is what I brought my lord's judgment. My lord has specifically dealt the issue, and they are also claiming that Jagjeevan Lal.
It's a different issue.
That's why altogether different.
Jagjeevan Lal.
Because he is
is a
not
different
to.
issue.
Yes, that my lord has already said that Jagjeevan Lal is a based on ACP, which has been as a feeder post of.
That's not the case here.
My lord, here,
So they want that should be that post, the pay scale has to be revised. So they want it should be revised from 4 to that is a 4/6. So we have the tribunal has said because it's I don't have a lack of merits because we cannot compare. He being retired as a fitter and he has never been promoted to the post of chargeman. So as per the existing.
So he has only got ACP.
ACP,
Yes,
Since he was not promoted,
Yes,
he's
yes.
got
He's got ACP. As per the existing
Occasions.
recruitment.
two
Yes.
occasions. First ACP, second
Second,
MFP. After 18, 12 and
Yes.
20.
We want to revise the pay structure.
on what basis?
I say, my lord, there can't be any discrimination so far as diploma and non-diploma holder are concerned. There can't be, my lord, because if my lord sees, I will place certain documents wherefrom it reflect that similarly circumstance employees who are not holding this diploma got the benefit of the higher scale of pay, but at the same time,
You say that you are holding diploma.
I am not holding
It's an ITA certificate.
ITA certificate.
ITA certificate, it's not diploma.
It's not a-
Other incumbents who are holding ITA certificate, they got the said benefits. My lord, if my lord recollect, my lord, Jagjeevan Lal was initially given ACP. Subsequently, he was promoted. And therefore, my lord has, that judgment, my lord has considered that his case is not similar.
It's different.
Here in my case, I also got the ACP. I never got the promotion. But when I got the ACP, I got the scale of pay of 45007000, whereas Jagjeevan Lal got the scale of pay of 5000, 8000. This was the differentiate which my lord in the order, my lord said he got the ACP first and thereafter he was promoted.
Yes.
Here
And
I
he
am
remained in the same scale.
Yes,
after
same scale,
promotion.
yes, that's why.
That is right.
So my case is that when Jagjeevan Lal got the ACP, admittedly he is also a non-diploma holder. Now, my lord, the feeder post for chargeman electrical and chargeman
It's fitter.
mechanical
Yes.
are same, similar. Both are fitter. So, my lord, when a chargeman electrical got the higher scale of pay, having similar feeder post, why can't a fitter mechanical who is entitled for the said post, and since he was not promoted, why can't he be denied? Because my lord, Jagjeevan Lal initially got the set higher scale of pay on the basis of ACP only.
In order to see the explanation.
What was his earlier scale?
His scale was 4500, 7000 when he got the ACP.
No, prior to that,
Prior to that, my lord,
the
the
base structure was same for these two persons.
pay structure was
And
same, my lord.
Jagjeevan Lal.
Same, my lord.
He was a feeder post.
No.
Lord has already clarified the position of Jagjeevan Lal because he was a lineman come meter reader. He was the feeder post in terms of the existing recruitment 1978 to the post of JE, junior engineer. So when he has not doing it, as I have clarified, Manoj has also pointed out that he has got an ACP. But
My
this
lord,
person is
no,
not
no,
at all come under the zone of that category because he is a, from the initial time he was a fitter. And it was not a feeder post of junior engineer JE at any point of
My
time,
lord,
as per the existing.
These two
annual.
feeder post, if my lord comes to page 149, the recruitment rule which my lord has also considered in that judgment.
142.
149, my lord. My lord, I'm sorry, this paper are not so legible, my lord. My lord, they have, these authorities have filed this, my lord, without any typed copy. 149.
Yes.
Serial number 13 is, my lord, chargeman electrical. Sorry, chargeman mechanics. This is what this instrument is entitled for promotion. Now, my lord, feeder post promotion from among fitter mechanics. I was fitter mechanic, man.
You are still fitter mechanic.
Yes, I
Because
retired
no
from
promotion
service.
is-
Yes. So, my lord, the next promotion post is chargeman mechanic. Serial number 14 is chargeman electrical. That my lord has dealt in earlier case. And here the feeder post is lineman assistant and lineman fitter. But what I am on, my lord, the feeder post of chargeman electrical and chargeman mechanical are fitter. in a particular category, my lord. Now, my lord, Jagjivan Lal was also not promoted to the post of chargeman electrical. As such, the benefit of ACP was granted to him.
Where is the ACP scheme? There should be an ACP scheme showing
Yes.
the increments one after the other.
That 1999 scheme, my lord, that has not been enclosed.
Lord, 107, I have given the chart, Lord, how far. Lord, will see it will clear from. 107, Lord.
107.
Yes, ma'am.
No, this is my
Lord,
learned friend.
how the
With
pay
regard to the
yes,
applicants.
yes. Pay fixation.
107 is something else.
No, this is with regard to
Lord,
the
this is a
scale of
details
pay
of
given
scale
to
of
the
pay, how
applicant.
it is fixed from 4 CPC to 7 CPC. The structure of pay with regard to 4 CPC to 7 CPC.
No, it's not like that.
Lord, Roman 8 may be seen, Lord.
Diploma holding and non-diploma holding, chargemen and
No.
junior engineers. They were made at par
Yes.
by the government notification.
Well,
But he is neither a junior, he has been granted ACP because he was not promoted. So he is neither a junior engineer nor a
My
chargeman.
lord.
So how is he similarly placed?
My lord, I say, my lord, first factual aspect is that, my lord, admittedly, the promotion post for fitters, electrical and fitter mechanical is chargeman electrical and chargeman mechanical. Jagjivan Lal got the ACP scheme since he has not promoted. And he got the said benefit 5,000, 8,000. He was not promoted. Subsequently, he was promoted.
He was not fitter.
he was
He-
lineman
fitter.
cum meter reader.
He was lineman cum meter reader.
My lord, that is the feeder post, my lord. My lord, may kindly see page 149.
The feeder posts are different for two categories.
Feeder post, no, my lord, may kindly see page 149,
149.
clause 14 at the right hand side.
Yes.
Promotion from amongst lineman, assistant, and lineman
Lineman.
fitter,
Fitter.
electrical.
LMR is not there.
LML,
LMR is not.
I say, my lord, both are fitter. Both are fitter and their promotion post is chargeman. So, my lord, the scale of pay of the fitter post was same. The scale of pay of chargeman was also same. When he was not promoted, he was given the ACP of chargeman. Now, my lord, I will show. My argument would be, my lord, that feeder post, both the scale of pay was similar and the nature of work was fitter. Now, my lord, the promotion post is chargeman, irrespective of the fact in which cadre they are there. Chargeman. When Jagjivan Lal was not promoted, he was given the ACP at 5,000, 8,000. Now, my lord, may kindly come to my supplementary affidavit.
Here also he has been given SCP 4500
45.
7,000.
My lord. But subsequently, he got 5,000, 8,000, my lord, ACP, not after promotion. 88. My lord, may kindly come to page 88. It's my supplementary affidavit. I have categorically said, my lord. This is the applicant is an ITI holder. Para 7, my lord.
You are not agreed by the 4500 7,000.
I am aggrieved, my lord. My prayer is that ought to be enhanced to 5,000 and the second MSCP ought to be gateway of 4600.
So where is this chart of enhancement? There's an ACP chart.
What?
Isn't it? Like this will be enhanced to this to this. I mean, where is that chart? So this is not done arbitrarily. It is one after the other.
Yes.
Where is the, we would like to see
My
that
lord,
chart.
that is a scheme with annexure I can.
Will not be kindly 110, Roman number 8, my lord, column number 8.
Once my lord sees,
My lord will say, my lord, I will come from the bottom. Left hand side, serial number 8, my lord. As
Yes.
per the fourth CPC, 1400-40, 1800-50, 2300. Then in fifth CPC, it was revised to 4500 plus 125 plus 7000. In sixth CPC, it was revised as 5220 and grade by 2000 as per the sixth pay commission.
no, this is
can-
their case, my lord.
No, this is a recommendation which is done.
My
by
lord,
the pay
can you
commission.
see page 94, my lord?
This cannot be arbitrary. There has to be
No,
charge
that's
for
the-
this. There has to be an
That
ACP
is a
scheme.
slab, my lord. It
Yes,
is
my lord, once
interconnected.
see page 94, my lord, what argument I am advancing, my lord. My lord, can you see page 94? Initially, my lord,
Yes.
this is 14th of February 2012. In partial modification of the office order dated 27/4/2010, the superintendent is pleased to review the ACP scheme. Sanction wide so and so in the scale of pay of so and so instead of so and so, revised so and so with effect from so and so. Now, my lord, this Jagjivan Lal, with what he has got, my lord, this was on the basis of revision, not on the basis of his promotion.
Yes.
My lord has categorically
Yes,
recorded.
That is the
Yes,
first
dispute.
Yes. So, my lord, why he has given that? Because the next promotion post was chargeman,
No.
which was not given to
That is the
him.
wrong pretext, my lord.
No,
That is
no.
the wrong.
I will show that subsequently. My lord has recorded in the order that subsequently he was given promotion to the post of chargeman.
Yes, he
Yes.
was retired at the post of charge.
Yes.
His applicant was
promotion
retired as a fitter. He's
Yes,
also
I am
retired.
saying so.
He's retired as a
My
fitter.
lord, my case is that I was never promoted after the post of fitter.
ACP is given when the promotion is not accorded.
Yes, when a person is stagnated in a post.
Yes.
Yes. So my case is that, my lord, I have been stagnated in a post. Subsequently, my lord, I have been given ACP benefit. Similarly, Jagjivan Lal was also given ACP benefit. Both their next promotion post is chargeman. Initially, he was also given 45,007,000. Subsequently, it was revised.
Around the-
Maybe seeking clarity.
Now, with regard to parity, he have to show that he also similar situated to Jagjivan Lal.
That
If
is
my lord
what
will
I'm
see,
showing.
no, that's what I'm showing. I will clarify the question. If my lord will kindly come to 148, because this is I shown in that earlier WPCT also, my lord. This serial column number 12, right hand side, my lord, bottom. I'm sorry, but it is not somewhat legible. May I read, my lord? 148, my lord.
Yes.
The position of lineman cum meter reader. Promotion from lineman cum meter reader. It was the feeder post of junior engineer. As my lord has come to the scheme of 2008, which says that diploma holder and non-diploma holder. So it was lineman cum meter was a feeder post. So he has to be revised in terms of my lord OM 2008, which is come into effect from 1/1/1996. So the pay has been revised, ACP has been given. As per the existing 2011 recruitment rule, the lineman cum meter reader become amended and it was been removed from this instant recruitment. It was made it as a feeder post of chargeman. So this is a clarification. And he is not a lineman cum meter reader because he has to be promoted to the post of junior engineer. As junior engineers already be given the pay scale of that enhanced pay scale 5,000 to 8,000. So he got it by way of revised ACP in terms of the 2008 OM, which was Melody is also relied in that judgment. But he is not similarly situated to this person. Melody he is fitter all along. He was a fitter, and the posts are both the posts prior to 1975 are entirely different. In 1975, fitter is not the feeder post of this junior engineer. Lineman cum meter was the feeder reader. And later on, when the amendment has took into place in 2011, they made it this lineman cum meter reader should be as a feeder post to be promoted to the post of chargeman. So that is the
So
difference.
this is prior to that.
Yes, this I'm not claiming for from third CPC because the position of 1978 to 75 recruitment. The 1/1/1996 he has been revised and a ACP has been granted in terms of the Government of India 2008 order. So he is not similarly situated. Will not be kindly 94 also. If will not see, these all our persons are lineman cum meter reader. No, let them show that a single person of fitter have been granted with this upgraded pay scale, then they have a case. Because all along these persons are not equivalent to them from 1975 to till
And
2010.
Jagjeevan Lal was lineman come
Meter reader. So he was a feeder post. That post was feeder post in 1975. The third CPCs came into existence, which was the recommendation. As Milord has also clarified in that judgment, that he has been granted ACP. As such, he has got the revised pay scale from 1996. But this person is not at all at the feeder post of junior engineer at that point of time. So he has not got it. So he cannot claim priority of that Jagjeevan Lal. Not Jagjeevan Lal is altogether is different. If could have been that any persons as a fitter from 1975 to 2010 have granted with this updated pay scale, then they have a case they can place before lordships. And as per the existing pay structure, my lord, in terms of the pay time to time recommendation done by the pay commission, fourth pay commission, fifth pay commission, sixth pay commission, the structures of the pays have been revised. And it is 2,800. In existing recruitment rule, it is 2,800 only, which he got an ACP as per that. And he has not challenged that also that it should be revised. He is only saying Jagjeevan Lal got it, so I also entitled to get. This is the only claim he has made before the tribunal, and which tribunal also consider that aspect in his judgment.
It is only on the ground of parity.
They are seeking only on the ground of parity. My lord, kindly, the operative part, it is clear, my lord.
Yes, you say similarly circumstance with Jagjeevan Lal.
Yes,
How are you?
that is the only parity.
If my learned friend conclude, I will argue. My lord, 149, my argument is, my lord, 149 clearly says that fitters are the feeder post of chargeman electrical and chargeman mechanical. Now, my lord will find that I will show one document, page number 20.
For chargeman electrical, mechanical, it is fitter. But for chargeman electrical, it is not fitter.
It is also, my lord, fitter, my lord. Fitter is there. Promotion from amongst lineman, assistant and lineman, fitter, electrical. With 15 years service. Thereafter, the trade and passing. But that's my lord. So, my lord, my submission is, my lord, my learned friend is in on track, my lord. My submission is that both are having promotion post of chargeman electrical and chargeman mechanical. I say that initially, if my lord sees, if my learned friend's argument is accepted, my lord will kindly come to page 27.
So both lineman and fitter are the feeder.
Feeder post of
Lineman come meter reader or not the feeder post. My lord, may kindly.
Let him complete because
Yeah, I'm sorry, my lord.
page 149
Yes, yes.
says so.
Now, my lord, page 27, my lord, may kindly come to page 27. What my learned friend has submitted is this document is compared to my learned friend submission. Now, my lord will find that page 27, it is dated 27 2010. In pursuance to the Ministry of So-and-so, dated so-and-so, and the recommendation of the elected Tribunal has been pleased to extend the benefit of financial upgradation under the ACP scheme to the following LMMR who have completed dual and 14 years of service. Now, my lord will find Jagjeevan Lal and other similarly, they got
This is for the LMMR.
Yes, my lord, 4500. I say, my lord, this is a feeder post. So next promotion post is chargeman. Therefore, if my lord sees they were also allowed 4500, 7000. My learned friend was arguing that since the said post is the feeder post of junior engineer, therefore they got the said benefit of 5000, 7000. Now, my lord, if that would be the case, then there is no occasion for the authority to pass this order, whereby the benefit was given 4500, 7000. Now, my lord, may kindly see they have reviewed it, page 94. Page 94, my lord. This order was reviewed.
Yes.
This is on 14th of February 2012. It says that in partial modification of the order dated 27/4/2010, that is page 27. the superintendent is pleased to review the ACP scheme sanction in the scale of pay of 5,000, 8,000 instead of 4,500. And Jagjivan Lal and all got the said benefit of 4,500, that's 8,000. If my lord, it is that it is the feeder post of junior engineer, in that case, there is no occasion for the authority to issue first order of 2010 and thereafter rectify the same. They could have straight away given the said benefit to the incumbents. Now, my lord may kindly see the next page, page 95, the education qualification of Jagjivan Lal. This was obtained under Right to Information Act, my lord. As the service record has qualified, passed AISSC, passed 2-year course of electrician from Model Training Institute. Next page is his service record. The same qualification is there.
See, he was also not a diploma.
No, he was not a diploma holder. Now, my lord, page 97.
Yes.
Page 97 is the benefit of second MSCP to him. At that point of time, my lord, he was a chargeman. He was given the second MSc 4600. Once, my lord, I get the scale of pay of 5,000, 8,000, that would be grade pay of 4200. So once if I succeed in the first ACP, then automatically I will get the second MSCP 4600. Now, my lord,
There was no promotion.
there was no promotion.
Yes.
Now, my lord, thereafter, page 98. This, my lord, will find that several LMMR, they got the benefit of second MSCP at 4600. Now, I will just show their
These
education.
are all LMMR. No fitter was given post.
My lord, I say that it's a feeder post of chargeman electrical as per page 149. And since they were not given the promotion, therefore initially ACP was given. Subsequently, they become chargeman. Now, my lord, I have enclosed their seniority list at page 102, my lord. My lord will find their educational qualification. Most of them are 10 plus ITI. Some of them studied only up to 10th standard. Serial number 9. Tenth standard, my lord. There are several. Serial number 9, serial number 27, serial number 90. Their name appears at page 98. Out of them, 12 persons' name appears at.
So will you please come to page 148?
My lord. (148).
Lineman come fit 9, column
Hello.
number 9. Lineman come fitter and LMML is on promotion from lineman electric fitter having 5 years service.
My lord.
So for lineman come meter reader,
My lord.
the earlier post is lineman electric fitter, which is the feeder post.
My lord.
That is not the case with the present.
No,
petition.
no, my lord. I say, my lord, this Absolutely correct.
These are not similar equivalent posts.
No, I say, my lord, this lineman, meter reader, and the fitter
They are
mechanic,
not equivalent.
no, mechanic, both next promotion post is chargeman, fitter, and chargeman. No, my lord, page 149.
That is 2011.
No, not 1314. My lord, I say, my lord, both were in the feeder post having similar scale of pay.
Lineman fitter's next post is lineman cum meter reader.
Right.
Jagjeevan was lineman cum meter reader. So that was not his feeder post.
My lord,
Second post held by him. Please see 148, the first
Hello.
column.
my lord,
Promotion from among lineman electrical fitter
having,
to lineman cum meter reader.
my lord,
149, the feeder post is lineman cum fitter.
but my lord, here also, promotion from among lineman assistant and lineman fitter, electrical, with 15 years of
Service.
then if my lord sees there is no promotion,
So there are two different avenues of promotion.
yes,
One is from lineman assistant lineman fitter to chargeman,
my lord,
and the other is from lineman electric
fitter to,
fitter to lineman cum meter reader.
my lord,
So this person was already a lineman cum meter reader,
my lord,
Jagjeevan.
my lord.
From there, he was
Next
to
promotion
posted
is to
chargeman.
chargeman.
Yes.
So this is my argument that next promotion post
But
is
this
chargeman.
man is a fitter which is below the post of Jagjeevan. They are not
But,
similarly
but
placed.
both are feeder post of chargeman in their respective cadre. Chargeman mechanical, I am my client's next promotion post is chargeman mechanical. Their next promotion post is chargeman electrical.
Jagjeevan was from lineman cum meter reader to chargeman.
My lord,
The other person was from fitter to chargeman.
correct.
So these are different.
These are different, but I say, my lord,
So
both
you
are
cannot
feeder
blame
post of chargeman. My lord, my argument perhaps is that they are both are working in a fitter post. We are working in a fitter, in
Feeder
a feeder post, the next promotion of which is chargeman. So I say then this feeder post of Jagjeevan, he got the scale of pay of 5,000, 8,000.
Jagjeevan was not at a feeder post. Jagjeevan was a lineman cum meter reader,
My lord,
which is not the feeder post.
but if my lord sees serial number 14, page 149, promotion from among lineman assistant and lineman fitter.
That is
Electrical,
different from
post.
this.
Different post.
Lineman fitter is one thing and lineman cum meter reader
reader
is
is
another
another
post. Jagjeevan was lineman cum meter reader. From there to
my lord, and in
chargeman.
that case, just I will ascertain my client is
The
present.
posts are not.
Just what was the scale of pay of both the posts? If both the post scale of pay is similar, then in that case, my lord, if they get the benefit of the higher scale of pay, definitely my client is also
Will
entitled.
you come back with the chart?
My lord,
With
let it be
the-
tomorrow, my lord.
Very- But there are counsels for the parties. Paragraph, the matter under the same heading for further consideration. Clear chart showing the posts and the scales. Wait.
Yes, yes.
Come back
My
with the.
learned friend can assist, he
No,
can
no,
assist
I can-
better, my
I
lord,
think
because he
yes,
has the
yes.
authority, he can come.
Absolutely,
Yes.
absolutely. Can you come back by tomorrow with this chart?
Day after tomorrow.
Wednesday,
Day after tomorrow.
6th.
Probably.
Please,
No, I am giving, let the Xerox and give back. Xerox करके दे दीजिए।
और दूसरा मैडम जो प्रोविजनल लिस्ट बना है गवर्नमेंट
मेरिट्स में अभी मत बोलिए।
तो लिस्ट जो बना है वो मेरे को लिस्ट डिटेल्स में लिस्ट उनके पास है गवर्नमेंट के पास वो मेरे को
Enclosed in the OA, my lord. That is the provisional list, my lord, is.
only the merit breaking में नहीं दिया है
শুনে নিয়েছি অলরেডি, এই ম্যাটারটা নিয়ে আর শুনবো না নতুন করে।
That's already mentioned about provisional.
নেক্সট ম্যাটার।
Item 8, my lords, will find that the CAT has recorded that the issue is pending before the Supreme Court. And my lord, in a similar matter, division bench has also adjourned the matters on this ground. Now, if my learned friend Mr. Kumar is in court, he can hand over the last order or current status of the Supreme Court proceedings. The issue is pending in the Supreme Court, my lord.
My lord, in this matter, I may have my lord's kind leave to address, my lord, on behalf of the interveners. We also took the privilege, my lord, to address the CAT. My lord, before going to any issues, my lord, the CAT order that being included before your lordship are very clear.
You see,
My lord, we are mostly agreed person. My lord, I'm sorry, my lord, I cannot hear, my lord.
sir, do you seek to intervene in this application?
My lord, intervening in the application to the extent, my lord,
Whatever the extent may be, if you seek, you are not a party here, right? If you want to intervene, you need to come back with an application. Yes.
Page 103, my lord, the CAT has recorded. Kindly see, my lord, even if, my lord, kindly see para 2.13.
as the courts of
An affidavit was called for, Mr. Chakraborty.
My lord, the current,
The effect that matters, the matter is pending.
officer, my lord, kind
On July 28, an affidavit was called for. Where is the affidavit?
to my lord, the order impugned.
An affidavit annexing
My
relevant
lord, kindly comes to my lord.
matter is
no,
pending.
no, my lord, that, my lord, we can file it by, I'm sorry, my lord, it should have been filed by an affidavit, but it is only the case status that we want to place before the court. Because I think there was some, perhaps we did not assist the court properly on that occasion. Kindly see, my lord, at page 103, what the CAT has said.
It's totally different.
Now, on the same ground, my lord,
People will
another division bench is also adjourned.
maybe post is.
Well, I believe, my lord, the honorable court may kindly comes to the impugned order itself. Kindly see page 129, my lord.
Please come back with an affidavit. There is already an order of this court.
Yes, yes, we'll file one.
Mr. Kumar, come back tomorrow, please, with an affidavit.
Your lordships are pleased to take up the matter tomorrow again.
Yes, you need to come back with an intervention application, sir, not before that. Party to
My lord,
the.
we are not made a party, my lord. The only problem is, my lord, the SLP, we are the party, we are the sufferers.
Maybe so.
We are the sufferers, my lord.
Please file an application for intervention upon service to the parties.
My lord, may I say this, my lord, your lordships have the power, my lord, to include, my lord, our clients as a party.
We
My lord,
cannot.
my lords are having, my lord, for the ends of justice, my lord, the orders which are being referred, we were, my lord, the parties to the proceeding. And
Maybe
we are the worst sufferers, my lord. Our matter is pending in the Supreme Court.
file an application for intervention if you want to. Learned counsel for the respondents seeks accommodation to use the affidavit as sought paragraph. Let the matter appear under the same heading on 5th tomorrow.
My lord, in one sentence, maybe, my lord, recorded on our part, my lord, that we have appeared, my lord, in, and your lordships, my lord, subject to, my lord, if they are so advised.
Respondents, the matter will be placed before the next available circuit bench.
Because next circuit come 25th August.
Yes, they need to
My
come back with
client
the
are sufferers,
affidavit actually.
I'll give an advance copy, my lord, because it has to be approved.
Come back.
For Blair.
Next.
Extremely grateful.
We are very sorry, my lord, it should have been filed. I'm very sorry about this one.
I mean, 4 of 25.
Granted, the supplementary affidavit is post affirmation to give advance copy so that this can be taken up tomorrow. Because in course, were called for by the first appellate court, based on which the first appellate court have modified the judgment of the judge. So not, because it was my argument that the were not made part of the application, so I've been granted liberty to take out supplementary affidavit. It's under the course of advance copy to my adverse side, ready to take it tomorrow.
Admission stage, your lordship.
Yes.
Second appeal.
Section 5 is something.
Section 5 was allowed.
Yes,
Yes,
first
it
one.
was.
Will you come back tomorrow?
Tomorrow.
On prayer of the appellant, the matter is adjourned for the day. Next,
Item 10. SAT 5 of 2025 with can 1 of 2025.
It's my appeal, Lord, is to have admitted the appeal. Second appeal, 14 July 2025, what may kindly be seen. Admission was done on the substantial question of law. So for the application is concerned, some protection for a limited period was granted. I have asked to serve
have you
the,
served the response?
I have given the notice.
With the appeal?
Pilot, I'm appealing for responding number 1 and 3.
What about others?
Was by to track report to the legislature. Because for one, he appears he is a plaintiff.
The judgment has been stayed.
For a period of 6 weeks.
You're asking for an extension.
But see, I'm still within time because for 6 weeks from 14 July. So it would be.
August, so it will be after the
Yes,
next
yes,
circuit, so
next
you don't need a
circuit.
further
No more
protection,
extensions.
yes.
Next session.
So let there be a direction for paper books, direction was not there.
It has to be sent back to the honorable single judge because admission has been done.
Yes, yes.
Substantial question, solitary question has been framed by the court. This has to be sent back to the single judge.
After preparation of paper books, right?
Normally, the normal practice is only for the purpose of admission, the second appeal is taken up. Once that is done, or should be sent to the single judge, then paper book direction. Upon the LC have been called for, trial court records have been called.
That will be done by the single judge.
It's been done by division also, it's been done by single also.
Yes, yes, because I think let the division bench direct,
Yes.
sir. Appeal has been admitted. Paragraph. The appellant, one appellant.
Solar.
The appellant is directed to prepare requisite number of paper books within 4 weeks of receipt of trial court records. Before that, trial court records we called for prior to it. The department is directed to inform the appellant immediately upon receipt of trial court records. Now it will go to the single bench. Then list it to this. Next,
Item 11, Night 18 of 2025 with can 1 in can.
Yeah, we seek extension time to prepare the paper book.
not ready.
Last circuit.
No, let it be last chance because 2-3 occasion chance was given.
Please give the file.
Yeah, paper book order. Paper book order.
Now finish the picture, but initially night is the evening.
No, June last circuit time.
Now June to
The respondents seek further extension of time to prepare the paper books. The matter be placed before the next available circuit bench. Paragraph, it is expected that paper books shall be prepared in the meantime.
But it is not respondent, appellant.
Oh, you, appellant, I'm sorry, appellants.
Blair.
And it is expected that paper books shall be prepared in the meantime and served upon the appellants, upon the respondents.
Item 12.
Exception
Review
here.
2 of 125 with can 1.
Exception there. My lord, there is.
Review of whose order? Which judges?
My lord, both the honorable lordships are not available. But my lord, in this case, my lord, there is a contempt and there is a review. Now, my lord, on the last occasion, we were directed to file an affidavit of compliance. Now, we have filed this affidavit of compliance. If they want to file an exception or they want to dispute it, then that is Mr. Kumar. What
Is
this
filed
paper,
by-
Yes, ma'am.
my lord?
The review application is filed by your
Review
department.
is filed by us, but notwithstanding that, we have also filed an affidavit of compliance. Because according to us, all the service benefits and including continuity of service, which he would be entitled to if the order is followed in letter and spirit, is being given to him. The only issue is that the nomenclature of the post is different, because according to us, and which is the subject matter in the review, that post has got deemed abolished. So because it's a deemed, and he's a contractual employee, he doesn't have a lien over the post, but he is working, he's performing the duties of that post contractually. So he is saying that the nomenclature should be X, and we are saying that in compliance of the court's order, we have given you all the benefits, including continuity, which is permissible for a contractual employee. But the designation of the post is different, because according to us, the post that he's seeking and which the division bench has also held in his favor, that post does not exist. So according to us, we have substantially complied with the order of the division bench, notwithstanding the fact that we also preferred a review which is pending. Now, whether on the last occasion, the honorable division bench felt that if he is otherwise satisfied, then it may not be necessary to proceed further in the matter, whether so the review or the contempt. But we have filed the affidavit of compliance and has been served on him. I am not aware what Mr. Kumar's stand is going to be. It will depend on that, my lord.
Lord, the last occasion they have filed affidavit in opposition and the court has granted me.
Opposition.
Opposition.
Compliance.
This is an opposition, my lord. I see.
Yes, opposition, my lord. Either way, my lord. It doesn't.
File an opposition, my lord.
Opposition to the contempt. So, my lord.
File an exception to that.
That
So,
was granted to you.
my lord, already the court's order is there.
Yes, yes.
So I am seeking an extension, my lord.
You
I
want
was-
to come back with
Yeah.
learned counsel for the applicant slash petitioner seeks extension of time to use an exception to the affidavit in opposition filed by the alleged protagonist. What about the review application? Do you want to use an affidavit to that also?
The other day, but my learned friend was harping upon the review, the court said, no, we will take that first. Last session.
Should be taken together. If the review is allowed, the contempt doesn't remain.
No.
So if you wish to come back with an affidavit in opposition to the review application, please do it at the same time so that both can be taken up. Yes,
But
Mr.
because there is a section
Yes.
also, my lord.
For review,
It's a delay of near about, I think, 1 year. So
it has not been admitted.
they preferred an SLP, my lord. Then SLP was dismissed. So,
So let the section 5 be allowed.
no, there is a delay of 1 year something, my lord. I will use my opposition to section 5.
On prayer of the applicant slash petitioner, liberty is granted to use an affidavit in opposition to the, I've stated on prayer earlier, I think, no? Except, oh, time, no? Time, to use an affidavit in opposition to the application filed by the review applicants under section 5 of the limitation. The review applicants shall be at liberty to use an exception thereto, if required. Paragraph, the matter replaced with. Please complete your affidavits in the.
Fine. Problem.
Next.
Item 40, 125 of 123. Granted the degree of divorce in favor of the, that's why the petitioner is that. I challenge that. judgment. And in that appeal,
Affidavits are exchanged.
the trial application under order 41 to 27, because the sole ground for which the degree was granted, the wife made unfounded allegations against the husband in the department, and the inquiry was conducted, and later on it was found that this is a
You are for the wife.
But later on, after the judgment, I got the order. And inquiry was conducted, similarly, inquiry was conducted in department itself. When this record was transferred to a tribal area. So he was living with that particular lady, whom I made a complaint that accidental affair. So the villagers made a complaint, inquiry was conducted, in the inquiry it was found that he was staying with that lady. But only reason the article was not true, because they are insisting for document, how can they document it produced for illegal relationship? Can you come to that?
The authority is insisting on documents.
Yes, this is a, yes.
And you want to adduce further evidence before the trial court. Order 41 rule 27 is pending, you said. Where is that application? Order 41 rule 27.
Remanding the matter because the objection filed by me against the order 41 to 27
Yes.
and their reply filed by them, kindly come to that.
After all, may I submit one first come to the charge, my lord. When you come to the opposition, to the order 41 to 27, at page number 12.
Of the paper book.
Not all three, the opposition might kind of.
Page
Part
10.
of the paper.
It is not part of the paper.
No, no, no. Yes.
I come to page number 12,
Yes.
the article of that number 1. That constable service law, by temporarily posted at IRBL, got Calcutta in the year 2019-20, resided with one married lady, which is Shakuntala, along with the respective children, in his own semi-RPC was considered with head constable service law, near Krishna Mandir, Calcutta and tribal area. Head constable Vigadan is already married person without degree of divorce from his actual wedded wife. He resided together with another woman in the tribal area. He just spread negative message to the tribal society and also violated the traditional tribal community of that highland. I just Rajan think the discipline was acted in an irresponsible manner against the ethics and culture of tribal community. That such an act of residing together with the lady, other than his legal wedded wife in the tribal area, on the part of a constable, rather amounts to grave misconduct and loss in the faith. This is contravention of mandatory provision of under rule 3 of CCS conduct for people rendering his life punishment under rule 2 of the case. This is one of the charge. I made complaint against this lady, which caused him mental agony. He filed his book for divorce on this ground. So kindly come to the analysis of page number 21. Page number 21. Analysis of article 1. In respect of the first allegation, all the 12 PW stand on the statement given and duly cross-examination revealed that the Shakuntala is staying at the RCC house of the Mira Pandya without rent, along with her kids. As a constable, Rajan son is also studying in the same class for Rajan professionally received 50 crystals from there. As per PW7, the statement of PW with the first captain of Manipali village, he corroborated the allegation of living relationship, but no documentary evidence produced. But it deposed that he made complaint to SHO PS Lanford regarding the relationship verbally, which may lead to bad impact on the tribal community, especially on you. Other prosecuting witness could not establish the permutation of both the Shakuntala and Rajan at Siri RCC building of the Pandya with any evidence and very prosecutor. All the witnesses seems to be hearsay, but both are living together in the same house. This allegation of article without documentary proof and on hearsay could not be substantiated. To insist for document, that cannot be given. For research, how can you produce a document? Only for this reason, this charge could not be put hearsay. So this is the sole ground for which the family court has granted the degree of divorce that I made the allegation.
Cruelty.
Good. That caused him cruelty. When it comes to judgment of the family court, it is clear. First, refer to,
Yes.
it is clear. Paragraph 51. Paragraph 90.
Yes.
The Department totally on first creating approach details that the human rights organization and state facilitator at the human rights commission made a complaint the same state region to director general of police to necessary action against 20.1% or inquiry. The matter was forwarded to PS started after the conclusion of the inquiry of inquiry report by at least one by one was submitted by SI 72. Started with the conclusion that the matter got inquired in various units of Adjournment for police was submitted report obligated finally stated as well as illegal relationship between the guilty and the is not free. Next paragraph. The department in order to prove the contention the plaintiff has applied the particular whom he ultimately married and examined herself on through the VW watch. In the affidavit of examination, she literally reiterated the principles of the statement. In the fourth examination, she practically stated that the no document to show the plaintiff has extramarital affair with her friend named Sumitra. He also stated that there is no document to show the plaintiff stay with one Sabutara at alleged by her. He admitted that the plaintiff reported without agreements with regard to allegations that she assaulted the plaintiff. The parent also examined one Timothy Laswa on her behalf on both at TW2, the TW2 in the currency and inter area stated that she acquainted with the sponsors who were once her tenants till the year 2011 comes to her test. The third DW also stated that she came to know that the plaintiff is having illicit affairs with her Sumitra. The third DW2 in that examination has admitted that she has no involved property record in her name. He has no document to show that his office was inducted as a tenant. He further stated that she is deposing on behalf of tenant his husband as well as her neighbor. The defendant also examined one Sangeeta, who is the secretary of Sri Mandir Welfare Committee on her behalf on both as DW3. In examination, chief DW3 feature area stated that one women constable, namely Sakuntala, illegally started partying at vehicle over temple land, and when the temple committee objected, he started filing frivolous complaint before the PS part of. It's effect of 31/23, as secretary, the said DW3 made complaint to the SHO PS part of. The said complaint has been not executed. He also stated that the said female constable and one head constable illegally living in the same house as Jindita. You have not examination that she in the areas stated that she linked one Anur who works at Subsidy in the legal department and one RS Aksini who works as a driver. He also stated that one Patwari lodged a complaint against the two persons who are members of the temple committee. She stated that she filed activity only after Patwari filed the said complaint against the temple committee member. He also stated that the said people is daughter of the said Parvati. He stated that she has no document to show that plaintiff is staying with the Kintala. He also stated that he has no documents to show that plaintiff is stay at ward number 1 where the threat is stay. Further, the threat is reduced by defendant in appearance to threat only for a period of examination sheet that plaintiff had affair with her friend namely Sumitra is to be pointed out as defendant in a written statement filed on 19/3/2006 no one mentioned that plaintiff had affair with Sumitra. No cogent reason has been advanced by the defendant as to how she was prevented from incorporating the same in a written statement. It is the premise of her attention. We have also defendant admitted that he has no document to show plaintiff had extramarital affair. He has said maybe Sumitra. The other witness, Nagma, who stated as that
So what is the additional evidence that you want to
I
adduce?
want the document which I got. The private inquiry was conducted, that was imposed upon the respondent. So my point is that I have proved it is not a baseless complaint made by.
When was the penalty imposed?
Or can come to my not by petition.
The paper book doesn't have 3 documents in between. After 25, it is 28. Is it the same in your paper also?
In my application at page number.
Oh. It is behind 26, 27. Yes, in the application, what is the evidence that you have
My
collected?
my application, 147, annexed
Yes.
E1 page number 11. After inquiry department. The municipal complaint in the tribal area, this punishment was issued. So, on to address this document. Which affected the bill that is having a crime with it. This is true. When appeal is made appeal, after all, modify the order. But punishment remained and now challenge the order before the tribunal and is pending for consideration. So order number 31st January 2022.
So you had this document with you before the judgment?
No, after January got. I was said in petition.
The judgment was on 19th April 2023.
That was not with me. Later on I got the document, departmental documents, later on I got. Then I immediately filed the application after getting this document.
Yes, what is your objection to this?
My objection is not, if they were aware about this document and she applied under the Right to Information Act to the authorities. And authority asked me from my client whether you are intending to give this document. It is my pleading in the opposition. So this document was subsequent to the pleadings filed before the family court. 2015 case was filed for divorce. Since 2015 they are residing separately. She made several complaints, which is appearing from the judgment passed by the family court. Numbers of complaints, 2007 to 2018, 19. This complaint, which is they are relying upon before this court. They made a half-baked cake before this court. In between, they submitted. But first inquiry report, the article of charge number 1 was not true. Article number charge in the inquiry, the disciplinary authority imposed a fine, but charge was not proved in respect of that. And subsequently, the appellate authority modified that punishment. That is also enclosed. And modified order also challenged before the tribunal, which is the subject matter. So this evidence will not help to the petitioner because petitioner made false allegations, which is admitted by her that I made complaints. Police authority inquired several complaints and found no substance in the allegation.
This is a subsequent disciplinary proceeding.
This is subsequently disciplinary proceeding where the probability and pre-prominence procedure is followed. The department gave me clean sheet that no article number charge was placed against me.
Earlier.
But time just.
But in this subsequent proceeding,
Time, no, nothing here, Lord.
you've been held guilty.
No, I will show that also. I enclosed all this. I nothing suppressed. Kindly come to page 24. The order of the appellate authority,
Page 24 of the paper book.
24 of the opposition.
Yes.
Kindly come to the order they are showing. I challenge that page 26 time. First paragraph. And whereas agreed by the order of the penalty imposed upon the appellant has now preferred instant appeal against order dated 4/2/2022 before the undersigned, being the appellate authority with the prayer to exonerate from the penalty imposed upon me by the disciplinary authority by order number second. The appellate appeal has mainly contended that finding of the inquiry officer is not based on the evidence adduced during the DE proceeding and disciplinary authority failed to evaluate the evidence adduced during the inquiry. Such contention of the appellant are devoid of any merit as on the basis of documentary oral evidence in statement adduced by the PW during DE proceeding, the inquiry officer came to the conclusion charge framed against him was proved, whereas in the first charge was not proved. Moreover, V. Gloria, resident of Mandir Committee, during examination and before the raised objection for construction of Pakka house. These were the allegations, this was punishment was given. And the statement given by the prosecution witness itself proved that no permission was taken for construction of Pakka house in the tribal area. Further, the appellant being the member of the disciplinary court had to uphold the highest level of discipline while posted in tribal area, but his conduct defamed the court against the tribal action. The tribal people unhappy and disturbed their sentiment. The undersigned have carefully gone through the proceeding of the DE and reveals the document on record that did not find any procedure left or denial or natural justice during the revisionary proceeding. The appellant was provided full opportunity to defend the case. The appellant has also been given a first hearing by undersigned on such and such. He could not adduce any new fact other than those already mentioned in his appeal. The report revealed the appellant during the responsible member of the fifth board has brought insult to the force by his conduct in tribal area, which is grave misconduct. Would have been agreement with the disciplinary authority that any leniency will send wrong signal to the other member of the court, but I feel the penalty imposed upon the appellant is bit harsh in comparison to the grave misconduct. Therefore, the sign has taken a lenient modify the penalty imposed by the authority of the only construction of house in the tribal area. And other article charge which was not proved that this will, finding is given by that charge is proved that you are reasonable doubt or whatever it is. So there is no proof of charge because they are not submitting that charge was proved against me.
So in the earlier proceeding or the appeal also,
Yes.
this subsequent departmental proceeding has not been referred to.
There is no subsequent department proceeding.
Please see the application,
This is the application.
can do,
Can do.
yes.
Your Lordship, first I enclose in opposition the order passed by the inquiry
Can do
officer.
is a subsequent proceeding.
It was
31st
still-
January 2022.
It was initiated, kindly come to take date of my opposition. It was initiated on 7 November 2021. By which I was, two charges were framed, article charge was not proved. Then against the inquiry officer, the authority imposed a punishment, which they enclose in their application. But the authority, I preferred an appeal against that order also, 2 years punishment was given, but no finding as regard that article of charge was proved against me. Either before the inquiry officer, before the disciplinary authority, or before the appellate authority. The charge was framed by the appellate authority, found that I constructed a house in tribal
This
area.
article of charge is with regard to the memorandum dated 12th November 2021. Yes. The earlier article of charge.
This is same proceeding. This is not a different proceeding.
So this proceeding was disposed of on
31 January 2022.
Where is the date? This is the appeal. On 7th October 2021, it was disposed of.
Yes.
An appeal preferred in July 2022
It is,
and disposed of
On 4 seconds.
on 4th?
no, 31/1/2022. As page 15 and their can application. I have remedy before the department to prefer an appeal. I preferred an appeal.
He was
Mm,
disposed
nine
of,
July 20.
27 of the opposition. This is the 27 of the opposition.
The appeal was preferred on 9th July 2022, right?
Closed out. What was the leak?
Last page, page 15.
So appeal dated 4th February 2022 and disposed of on 9th July 2022.
Right.
Now, the departmental proceeding that is indicated in the can is on 31st January 2022.
Just by this page 8 of my opposition, it was the initial memorandum of charges was given.
Yes.
Then inquiry was conducted. And both the charges was as they enclosed in their 10 application, that was the charges. One of the charge number 1 was not proved against me during the inquiry. And thereafter,
No, this proceeding was complete. This proceeding was complete. You preferred an appeal that was
Appeal.
also disposed of,
Yeah.
right? But this is a separate proceeding.
no, it's not separate proceeding. Let them say it is that separate proceeding. First inquiry report, inquiry officer submitted his report to the disciplinary authority.
This is order book number 237 dated 31st January 2022. Was that considered in the earlier matter before the family court?
They did not produce this. Page 24, kindly come to page 24 of my opposition. 9th July 2022 is the order passed by the appellate authority.
Yes.
There was no article of charge number 1 was proved. This giving this document which was in between the inquiry report and the appellate authority order.
Yes, but this order has not found place in any of the earlier proceedings.
They suit was filed 2015. They alleged complaints which was referred by the family court was in 17, 18 and 19.
The application says that they came to know about this document in December 2024.
They may say on affidavit whatever be, but my submission, I also submitted in my application that they applied this document under the Right to Information Act, which was not supplied to them. How they can get this document?
Where is the reply of RTI? That it could not be supplied to them?
With the department, I have made submission in my application. They also made submission in their application.
Where is that submission in the application that
Yes.
they applied under the RTI?
Yes, please. Para 3, your lordship. Page 2, para 3 of opposition. Further, the confidential document, how it came into the hand of the applicant has not been mentioned in the application. Further, there is nothing mentioned about the source of this document. It is submitted when the applicant was aware of this document. She had opportunity to call the authorities at the time of evidence. And in this regard, nothing has been done. It is important to mention here, respondent received phone call from the department when the applicant applied for document under the Right to Information Act, and no consent was given by the applicant to provide the personal document to the third party. As for the information, department refused to provide the information sought for under the Right to Information.
We would like to see the application under Right to Information Act.
Number 6 stated, the paragraph 11 of the application.
I will take the documents from the department, when she applied under the Right to Information, I place this for this court.
Paragraph 11 as stated.
You applied under the Right to Information Act. Where are those documents? You have suppressed them before this court.
Yes. Now
If
they
it
are
is
saying-
rejected,
Now they are
if
saying.
it is rejected being confidential document, how did you get hold of that document?
But they filed the appeal with Tribunal. Same daughter they have challenged. Later on, got the copy.
How did you get the copy? That's our question.
Kindly see the reply para 3.
A well-wisher cannot give you a copy of
Yes.
a,
Well wisher.
One of the current well, Mr. Tribunal, got the department.
so that was illegal.
They challenge your tribunal.
If the wife is not getting the document, a well-wisher gets the document and
Yes.
gives it to you.
Because tribunal, now it's not a confidential document, no more.
You are not
But
get it
the
from the
challenge
tribunal.
I don't get it, the
You are
document.
not got from the
Which
tribunal.
matter, this application, this document was challenged before the tribunal.
20%.
They are saying they got under the Right to Information Act.
Yes.
Para 3. It is a contrary statement.
Funding now.
And more so, when I amended my
Where are
claim,
those documents? Sir, you've made a half, you've not annexed all the relevant documents. The RTI application, the refusal, and now you say that what is pending before the tribunal? How do we know? You are not, which order? This order has nothing to do with that document. Yes, that has nothing to do with the document under order 41 rule 27. Please come back with the relevant documents. And not only that, I feel that you've referred, that doesn't contain this document. So how do you say that it is no longer a confidential document? Who has placed the document before the tribunal? Who has filed this document before the tribunal?
because penalty of report. Last order, by last order, I have to challenge the before the tribunal. It is pending before the tribunal.
So have you furnished this document before the tribunal, the one
Yes,
that he wants to,
Yes,
the 31st January 2022 document?
Yes, I challenge before the tribunal. Challenge before the tribunal. But how they can get this document? They applied under Right to Information Act. Their paper was refused. Then
Yes, sir.
they get through well-wisher and on affidavit they are saying, who is that well-wisher? From the office record he is providing the document. to them.
Social
It
media.
is very serious. Social media, this
Where are
document
those
is available.
averments?
After filing.
Where are those averments?
In social media, this departmental proceeding will be available. Kindly see the.
Because you have not stated that the document is an official document now. Where is that ever?
Paragraph 3, right, stated.
Concerned about get judgment from the court or from RTA.
Reply.
Paragraph,
Paragraph 3.
Which it seems was denied, but they get the document from our well-wisher.
Oh. Yes.
There is
Sir,
no
page
page
two
number
is,
2 in this
missing.
reply. There is no page number 2 in the reply. Manoj? Here also friend and social media. Where have you stated that it was placed before the tribunal from where you got a copy?
but the same was denied, I made, I already commented that the same was denied, but petitioner, there's a document to friend and that got social media.
Where are those documents?
You have to disclose, you have to disclose clearly as to on what date or at what time did you.
The social media clippings that your friend gave, because you cannot get a hold of a document which was denied to you officially. That is illegal. A proceeding has to be started against the person who has provided you with the document also. Right?
You must have disclosed the name only,
Everything.
the person from whom you.
You got the document so that we can take necessary steps against that person for disclosing a document which was refused in RTI. If you would have stated that the document was filed by the respondents before the tribunal and you got a copy from there, that would have been fine. But what you say is after refusal, a friend has given it to you. Now these friends are very dangerous, we must say. And the friend falls into trouble for you, for a friend like you. Please come back with a supplementary affidavit. We will not deal with this like this. Heard learned counsels for the parties. The appellant seeks liberty to adduce further evidence before the learned trial court to bring in evidence an order passed by the Commandant, IRBN, Andaman and Nicobar Islands on 31st January 2022. Learned counsel for the appellant submits that the said order was not within his knowledge when the judgment was delivered and he received such document only in December 2024. Paragraph, it appears that the appellant filed an application under the Right to Information Act before the authority for a copy of such document, which was refused by the authority. Stop. The appellant says that the document was provided to him by a well-wisher. Where is that paragraph?
Paragraph 3 of this.
/ friend who works in the department of the respondent. and also through social media. Paragraph, on prayer of the appellant, liberty is granted to use a supplementary affidavit disclosing the name and details of the said well-wisher slash friend, and also under what circumstances he was handed over such document which was refused to be made over to him by the authority in reply to his application under the Right to Information Act. Paragraph, the matter be placed before the next available circuit bench. Next matter is a short matter, 15. Yes. You are the appellant. Paper books ready? I think this will take some time. So let it be shifted to the next circuit by consent of both the parties. By consent of the parties, the matter be placed before the next available circuit.
Item number one, Petition 2024.
You're agreeing on mediation?
Yes. Let it be sent.
Yes. You are the
I'm
respondent.
for this.
Learned counsels for both the parties submit that the matter may be sent for mediation. Paragraph, in view of the above, comma, learned registrar, comma, circuit bench, comma, High Court, comma, Calcutta is directed to take necessary steps for sending the matter for mediation. Paragraph, the matter be placed before the next available circuit bench.
Item number two, affidavit MB 2 of 2025.
Mediation,
Once again, we can try. They
Same
ordered the check, and I have to.
same on.
Item number three, affidavit MB 4 of 2025.
And for the appellant here. This is not
Who is the
appeared,
respondent?
last occasion, this is not appeared in the.
Fine. This is also a fit case for mediation, I find.
2018, this award was passed. They have challenged this delay condoned. But facts is that application was under section 163A, but it was dealt with under section 166.
6.
That is the issue. Even though we can try for mediation if other party comes.
Yes.
You are the respondent?
Yes.
Let it be
Let
said,
it be sent to mediation.
the same order.
Item number four, CRMA 4 of 2025.
Okay, my lords, this matter, as I request to be kept in abeyance because 6 and 7 are the respective 482s. My lords have passed an order pertaining to the same FIR on Saturday, which is in case number CRR number 45 of 2025. The de facto complainant, everybody is available on the video conferencing for the item number 6 and 7. They are 482 pages, 528 pages. So this is a bail application, so this may be kept in abeyance as if a settlement is being arrived at in those matters, so.
So on your prayer, let me just record that it will be placed before the next circuit. In the meantime, if that can be done.
Lordship, may I submit, Lordship?
Yes.
On Saturday, another application was moved for quashing of affair in respect of another petition. There are 6 accused persons in this state case. FIR was chalked. It was huge financial irregularity. That currency about what happened was
PC Act, right?
no, not PC Act, cryptocurrency. Near about 162 crores have been frauded by the petitioners. 6 accused persons. Since beginning, one by one petition is filing, Lordship. First anticipatory way, then quashing of the same person. Then another quashing of affair for other accused person. On Saturday, I was out of station. That petition was moved. There was a order passed by this court not to take any coercive steps, Lordship, till the next day, Lordship. But since 7 years, the investigation officers are coming with the case diary, Lordship. That is the difficulty, Lordship. One by one, because that last order, the investigation officer unable to proceed further regarding that part. That is the difficulty, Lordship. Since 7 days.
Is going
May I
on.
intervene, my issue for a moment if I'm permitted to do so?
And
That an amicable settlement is being
Lordship,
arrived
that
at.
was a non-compoundable offense. If something,
That's the reason why I kept.
Lordship, non-compoundable 409.
In your absence.
Lordship, first, second, yesterday, out of 6 accused person, one was arrested, who is a permanent resident of this. Today, he have been produced before the Court of Chief Judicial Magistrate. Another 5 or 4 accused person, they are not a permanent residents. They are residing at mainland. So many difficulty, Lordship, since 7 days, it is pending. Hearing is not concluding. The IU is under difficulty. Yesterday only was residing here. Non-cooperation of the under section investigation 41A EA notice was given to all the accused persons. In spite of receipt of this, they are not coming.
It's all below 7 years.
My lords,
Lordship, more than 7 years, Lordship, even though, Lordship,
This was.
Lordship, even though, because financial irregularity,
my lords,
cryptocurrency offense, not required. Unless Kumar judgment not required, even though not,
Listen, without a warrant, yes.
Lordship, but they are not even a cooperative,
my lords,
cooperative.
my lords, if I may submit, my lords. Lords, for the last 17 days, the concerned accused in question, which my learned brother friend on the other side said, has been going to the police station, signing the diary, cooperating with the investigation. The principal accused, on whose petition my lords had passed the order on Saturday, had also voluntarily came, surrendered. The police was not willing to arrest them. They were detained illegally for more than 72 hours, which if my lords may recollect, I had mentioned the last time I had appeared before my lords. Then they were let go off because we had made a mention here in this court. Subsequently, a 41A was being issued only because there is a 316 subclause 5 which has been arrayed by the police. Now, my lords, the de facto complainant is also there. A settlement has been arrived. End of the day, it's a financial fraud. Whatever the case may be, the de facto complainant, we have reached a settlement. We are signing an MOU which we wanted to place it before my lords. And my lords may pass the order accordingly based on the MOU. We were willing to surrender our passports. We were not willing. If we were to run away or we were to arrest and we were to run away, my lords, why would we come and
Let
cooperate with
the
the
anticipatory bail application be kept in abeyance till they have also filed a quashing application. I believe.
Lordship,
That is,
This is item number 6 and 7 in today's
6 is,
Aza Enterprises.
Aza
Latifa
Enterprises.
Banu, Mohammed Basim.
7 shows your name.
My other filing counsel's name is there in the other, Sujadip Malik.
Now, who is this Aza Enterprises?
Aza Enterprises, basically what has happened is, my lords, the list of accused are as follows. The de facto complainant in their complaint has added that there is a company called Aza Enterprises Private Limited, 2 directors, Mohammed Basim, Latifa Banu, Mohammed Basim, Madras Latifa Banu. Then there is one more gentleman called Vaibhav Gupta, then there's one more gentleman called Saurabh Diwan, and then there is one Mr. Ravindra.
You are arraigned as an employee of the company, right?
No. We were basically, my lords, to give an explanation, this was an over-the-counter cryptocurrency dealing where a certain payments were made by the de facto complainant.
So you are not part of this company, the company and you, it's that way.
Yeah, that way, yeah. So,
So let it be kept in abeyance till 7 is disposed of.
yeah, so I am not part of the company. So far as Vaibhav Gupta
You are
is
related to 7, item number 7.
I am related to item number 7. I am also appearing for Aza Enterprises, Mohammed Basim and
No, you will be appearing, but
yes,
let this be kept in
they
abeyance
will
till
be kept in
7,
abeyance.
yes.
That's what I am also humbly submitting. But this will be kept in abeyance because if a settlement is arrived.
The petitioner has filed an application being CRR 34 of 2025, seeking quashing of the FIR lodged against him. The petitioner the petitioner submits that the present application being CRM A4 of 2025 be kept in abeyance till the other application is disposed of. Paragraph, such prayer is allowed.
Lordship,
6 and 7, as and when my lords call.
Let me call. Let
Yeah.
me call. Yes,
Yes.
5.
Lordship.
Item number 5. CRMA 5 of 2025.
Your Lordship, I have finished them. The allegation is under section 376, Your Lordship. Now, Your Lordship, this is a case relating to promise to marry. The entire case made out by the prosecution, Your Lordship, the complaint, the basis of the complaint is promise to marry, Your Lordship. Now, Your Lordship, here, I would like to project before Your Lordship that when the problem, because they were, it is a case of the complainant herself, that they were in relationship for last many years. Now, when the problem started, when their family there was some dispute in the family, when that dispute got aggravated, Your Lordship, she went to the women's cell and after going there, she lodged a complaint that I was called in the women's cell. There were also arguments were there between the parties in the women's cell. Then I requested the women's cell persons concerned, that are police officials, that I may be allowed to see the complaint, what is written in the complaint. Then I noted the complaint also, and I'm just showing that complaint. It is at page number 14, which I have noted. The records can be called for, Your Lordship, from the women's cell, and Your Lordship can very well find out that this is the contents. I'm just placing, Your Lordship, it's very important. I, the undersigned applicant, would like to bring certain material facts before your kind perusal and necessary action against the above said three persons. That in the year 2016, Shri K. Hemanta Rao, Appa Rao, this approached me for the proposal for love, as I was in class 9 studying in GSS Rangat, did not pay any heed to the said proposal. That K. Hemanta Rao approached my mother, namely Rama Devi, and convinced her for the said proposal of marriage. But my mother made him clear that as I was minor, and once Shri K. Hemanta Rao gets settled in his life, we both can marry, as both the family will arrange for the marriage. That since from 2019 to till date, K. Hemanta Rao is in touch with me over phone, as presently he is posted as constable in CID branch, and before this he was posted as territorial army for over 5 years. During all these years, he was very nice to me and always made to believe that he is going to marry me very soon. That from last
Make it happen, sir. My lords, since my lords was
Have you served?
the the PP has been served, the private respondent, the private complaint, de facto complaint had appeared before my lords because he's aware, he's there, he's on
Is he
the.
appearing for-
also there. Yes, yes, I'm appearing, my lordship. My lordship, if it could be possible, the same orders may kindly pass and we can keep it for 7th because in between the MOU will be signed and we'll be placing it on record. So subject to the deposition of the passport, the similar order may kindly pass. I have already instructed the client, they'll be flying to sign the MOU, my lordship. In case they have some difficulty with the visa application, we will seek adjournment with the kind consideration of the Honorable Court.
Not for the petitioners, right?
Yes, my lords, I just have one submission. Post my lord's order on Saturday, there has been a very vindictive approach by the concerned investigating officer and the concerned, more specifically the SP, who has already been asking for gratifications to place this current accused also on an arrest today. He was produced before the concerned magistrate. We had made a mention for the matter to be passed over, stating that the connected matters are listed before my lords. And based on my lord's order, he may proceed further. Lord, my only request is till 7th, if the investigation can be stayed.
No, cannot.
Or
These two persons are in custody now.
my lords, Mohammed Naseem is in custody today. He was deliberately taken on custody, despite he joining the investigation almost every day. Rather, every day, my lords.
To file a bail application, which
We've already filed it, my lords. My only request is still because his presence is required for this MOU to be signed. If he's placed on arrest and he's in police custody or
You
in.
can get it signed from custody, no difficulty.
Well,
That cannot stall the
the
investigation.
entire case, I'm not stating that investigation may be stalled, my lords. I am not leaving Andaman. I'm a permanent resident of Andaman. I will join the investigation. I will stay from morning till evening, whatever time the concerned IO wants me to stay. This is only till 7th month.
No, you're already arrested.
Yes, my lord. I've been placed on arrest vindictively after my lord's order was.
Which will be considered by the court deciding the bail application. Once you're arrested, there cannot be any further orders unless you're granted bail.
Indeed, my lords, but when a settlement, when the de facto complainant himself comes with it,
No. Mr. Ramakrishna, I think my lords are right. My lords, what I would request at this juncture is this. If my lords may kindly observe, the subject to the settlement arriving at, the court below can consider my bail application, their bail application. And I think that will be sufficient, my lordship.
Any comment on that, sir? I'm sorry. Let the court decide on.
If I can, in case I can become.
That matter regarding, because the accused was already arrested, today produced.
Yes.
According to law, that will be posted, that different issue. Regarding that matter, on maybe fixed on 7, no problem, but no interim order regarding the stay of the investigation. Not.
The matter is reaching a settlement. And the entire.
This is an uncompoundable offense. We need to see whether this settlement will really absolve you. I don't think it will absolve you from the.
My lords, the matter on merits, we would argue this on 7th, my lords, on why that concerned offense also is not made out. If such a situation is so required, we would definitely argue it on the fact that why 3165 does not get attracted at all. But considering the fact that it's a private dispute, it's a financial dispute between two parties. The de facto complainant is also before this court.
Is it a
Specifically
complaint
stating.
case?
Huh?
Is it a complaint case? No, it's a police case.
My lords, if a complaint has to be extracted
at large, right?
if the complaint was to be extracted as is verbatim without any documentation or anything to be taken, more specifically, my lords, 316 subclause 5 categorically states that it is for a broker, attorney, factor, and other things. In the event of no agreement whatsoever, no document, no trail, nothing whatsoever, then that's a matter of my lords, it's a matter that goes into merits, which I would ideally wish to argue it on 7, because if I have to place this on record, whether the section is attracted or not, I have case laws, my lords, to substitute the Honorable Supreme Court case laws to substitute. I have even if the investigation diaries are called for, while my learned brother on the other side very categorically and vehemently contended that, we never cooperated with the investigation. Well, the CCTV footages of the police station, the area CCTV footages, the diary that is written in the police station, none of them can lie. The petitioner herein has
But
been coming to
since
the
one
court
matter
for
is
last.
appearing on 7,
Seven.
these matters also appear on 7, and it may, they may have to come back with an affidavit, I think, on
No,
annexing those relevant documents.
no,
The CCTV footages, etc. What all.
well,
you have been
let the entire investigation diaries be called for, because
CDS with me today also, Lord.
concerned superintendent of police behaves as though he owns the entire place. He is asking for gratifications, which is uncalled.
Baseless allegation at this stage,
You put that on.
No, this is a post facto. This is a post facto, my lord.
With a supplementary affidavit.
And no, we are moving a police brutality rate and we are asking for a departmental inquiry and a vigilance case on that gentleman, my lords. That's a different thing altogether. Because, my lords, he has kept these concerned accused who have joined investigation voluntarily for more than 72 hours. There is proof of this. He has confiscated devices. He has called expert at his private expense. My lords, if there was fracture of any law possible, everything has been untwisted and done by the gentleman.
Part of English violation, an allegation has been taken. So kind of appreciate. Suspected.
My lord, Caesar, for 15 days he's holding the last time.
This circuit. That's another practical difficulty. Now, if these matters are argued on Thursday, I don't think they can be completed. That's another difficulty.
I understand, my lords. We would probably, my only request would be in that case, my lords, that mark that started, and then if my lords may wish to take it up once my lord reaches the parent.
They are already overburdened.
I understand. It's just a request.
We sit with.
I could only request.
300 matters.
No, I could only request, my lords.
We can carry these matters to the main.
My lords, if I can make a mention, my lords. My lords, I appear in CRR 45, my lords, where your lordships has passed an order on Saturday. My lords, this action comes, my lords, as a counterblast to your lordship's order. My lords, till then, my lords, both the accused were appearing. My lords, now the settlement talks are there, my lords, we are entering to compromise.
It was an order for this particular person only.
Yes, my lords, I am absolutely there, my lords. Now, as a counterblast, my lords, they are now, my lords, trying to arm twist. My lords, some protection, because, my lords, the MOU has to be entered by all the parties there.
My lord, we would have moved matters.
Some protection, my lords, for them, my lords, because, my lord, the magistrate has also considered stating that, my lord, some orders passed by this honorable court. My lords, now the parties want to settle. My lords, in this kind of matters, my lords, the accused never comes before the court. My lords, we have voluntarily come before the court. We have surrendered the passport. We are showing the bona fides, my lords. Now, police, my lords, coming in the way of the compromise, my lords, might become a little tough. Kindly let the matter be posted on 7. Some protection can be given for them also.
Issue to be considered.
Well, that would come in the purview of Jansi.
But we do not know whether that can be accepted at all. Let us see.
My lords, just because, my lords, it's frustrating, my lords, the entire settlement which is going to happen.
My lords, the entire settlement will collapse, my lords, if this arrest happens, my lords, and then it will be.
We have come voluntarily, and my lords, for more than 15 days, he has been cooperating.
Either collapses or remains. Only because the private party is coming to a settlement with regard to a non-comportable offense, we cannot say that you're absolved.
My lords, there are instances, my lords, where, my lords, in the crime stage itself, the court has seen the bona fides of the parties and allowed. My lords, this question will argue the matter, my lords. This question can be argued. My lords, as an interim protection, my lords, to argue the matter, because, my lords, whatever the circumstance we are standing today, my lords should not frustrate is what I'm seeking, my lords.
Let us see. That the
issue
has been amicably settled between the parties, and memorandum of understanding shall be filed on the adjourned date. The petitioner agrees to the second petitioner, right? It is submitted that the first petitioner has been arrested. Second petitioner agrees to deposit her passport before this court in course of this day.
My lords, in case of Vaibhav Gupta, this is CRR.
This is not Vaibhav Gupta. I'm dealing with CRR 33.
Mr. Wasim's passport has already been confiscated by the IO.
Mr. Wasim is has been arrested.
No, his passport was confiscated way before in contravention to Maneka Gandhi.
3, petitioner number 3,
Latifa Bano, we will submit the passport. That
to be 3, not 2. 2 has been arrested, 3's passport will be submitted.
Yes.
And let the matter appear under the same heading on 7th August. No coercive steps be taken in against the third petitioner. She's a lady.
She is doing.
The third petitioner in
She's
connection
actually
with
joined
the
as
present
the
matter
damage.
till the adjourned date.
Obliged.
and well as the same order follows for Mr. Vaibhav
Yes,
Gupta as well.
yes. For 7, no arrest and all that. Passport deposited, single petition.
Well, in that case, I'll be able to deposit the passport on 7 because the gentleman is a mainline. He's saying that he would courier it to us or whatever. the
Not
case.
today.
Today would not be possible, my lord, because he's in a remote
The
location.
petitioner undertakes to deposit his passport before this court by the adjourned date.
Much obliged.
The remaining, he's saying the remaining, only that arrest part will not be there. There are 3 parties.
Item 8, CRR 35 of 2025.
My lord, I am appearing for the petition. This phone. My lord,
I pray not.
Yes,
I pray not today.
not today.
Not today, because there are 4 to 5 applications for quashing of the entire charge sheet. Earlier occasion, application was filed for quashing of the FIR, which was rejected by the Supreme Court. Thereafter, quashing of charge sheet, but not for this.
On prayer of the respondents, the matter is adjourned for the day.
but
Next,
Public.
from 8 to 11, similar matter.
yes. 8 to 11.
11. Arising out of same charge sheet.
Item number 12. PO 7 of 2025.
For the petitioner, my lord. My lord, in this matter, 4 of the defendant has been served, but the rest of the defendant, there are 11 defendants in this matter.
So,
Yes.
since service upon all the respondents is not complete, the matter will be placed before the next available circuit bench.
Thursday.
Thursday will not be possible. Next,
Oh, all right.
Item number 13, CO 50 of 2025.
Yeah, challenge the order passed by the Leonard Civil Judge Senior Division, my lord. Yeah, have challenged.
have you served?
No, my lord, there is a civil division that
No. So it's a new matter.
new
New
matter.
matter. Okay, first.
Lord, here I have challenged the maintainability point, my lord. As per the jurisdiction of the court. Because the civil court, because the order which they have challenged, what they wanted in the plaint, that is an appealable order under the Land Revenue and Land Reforms Regulation. Because the order passed, the action taken as per the Land Revenue and Land Reforms Regulation, there is the appeal provision. That they have not opted and they have filed the civil suit.
Please show me the relevant
My lord.
orders.
My lord, yeah, my lord, the plaint, in the plaint, the caption is plaint is at page 31, my lord.
Yes.
And they see they have filed the plaint for suit for perpetual injunction and declaration of manufactured sketch map of land bearing survey number 285-286 situated at Vandu village as null and void. My lord, and the prayer portion kindly be seen, my lord. Prayer is at page 41, my lord. Page 41. A
Yes.
decree be passed declaring the present manufactured sketch map of land bearing survey number 285-286 total area 2.02 hectares situated Praga as null and void. My lord, here 2.02 hectares was allotted to their father, plaintiff's father. That was purchased by me. And after the purchase, in the year 2018, resurvey was conducted. And as per the resurvey, the settlement was done. Now they have challenged that. My lord, under the regulation, 51 says for the resurvey, who can do? This can do by the settlement officer.
Regulation.
Lord, it's a section 51, my lord. First part, my lord, regulation. The settlement officer may either renumber survey numbers or subdivide survey numbers into as many as subdivision as may be required in view of the acquisition of rights in land or any other reason. The division of survey numbers into subdivisions and appropriate of assessment of the survey number amongst the subdivisions shall be carried out in accordance with the rule made under the regulation, and such rules may provide limits either of area of land revenue or of both, which no subdivision shall be recognized, provided that the total amount of assessment, that is the thing. So as per section 51, the settlement officer has done the work. Now, 28 says, my lord, if section 28 is the appealable, appeal, revision and review. In this, section 28E kindly be seen here. If such order is passed by the settlement officer, whether exercising the powers of the settlement officer or the powers of the deputy commissioner in connection with any settlement officer to the settlement commissioner. So whatever he wants, because as per section 51, the recognized survey numbers were finalized here, my lord. In the resurvey, because these survey numbers, it is in the name of my client, the petitioner herein. The respondents, they are mere encroachers, because whatever land they had, 2.02, that was
sold out to you.
sold out to me. I'm the recorded tenant now. Now they are challenging this by filing a suit. When there is a provision under the statute.
By whom was the
And
survey done?
204, what says here, my lord, that also made seen, my lord.
By whom was the survey done?
My lord,
Where is the survey?
I have annexed the document, my lord. My first document starts from page 71, my lord. Page 71, my lord. Page 71. It's in the name of Siddhartha Resorts and Sports.
Yes.
Recorded both the survey number 285 and 286. My lord, there is a sketch map thereafter in page 73.
Now this should be done by the subdivisional officer, right?
Settlement officer. Because resurvey will be done by the settlement officer, my lord. The settlement officer has done the work. Now the provision is there, and there is a bar to file a civil suit. That is also there in the regulation. Kindly see, my lord, 204. Kindly see once, my lord, 204. Page 2, my lord, regulation, my lord. Regulations 204.
Yes.
No suit or other proceeding shall, unless otherwise expressly provided in this regulation, lie or be instituted in any civil court with respect to any matter arising under or provided for this regulation. Here, my lord, section 51 is there. There is an appeal or provision is there, appeal provision. They have not chosen that, and there is a bar to file a civil suit.
What is the judgment include?
My lord, it's a page, my lord, 147, my lord. 147.
10th July judgment?
My lord, 147.
Oh, your maintainability issue was turned down.
Turned down.
That application was turned down.
Turned down, my lord. First, my lord, jurisdiction point has to be decided, my lord. It can be decided at any stage. The latest judgment of Justice Dipankar Datta Sab's, that judgment is there, my lord. At any stage, maintainability can be
Absolutely.
raised, my lord.
16th September is the next date, so you don't require a stay at the moment,
My lord,
right?
my lord,
Please serve and come back before the next circuit.
my lord. Because only now the WS has been filed, thereafter I filed this maintainability application.
Yes, it's fixed for framing of issues,
My lord,
but that is after the next circuit.
my lord,
So you don't require a stay. Nothing
My
will happen before that.
my
date,
lord,
right?
my lord, my lord.
The petitioner has assailed the order passed by the learned civil judge senior division Port Blair on 10th
July.
July 2025 in OS number 79 of 2022, turning down his prayer challenging maintainability of the suit. Paragraph, learned counsel for the petitioner submits that the resurvey, which has been challenged before the learned civil court, was conducted in terms of Rule 51 of the Andaman and Nicobar Islands Land Revenue and Land Reforms Regulation, 1966. And Section 28 of the regulation envisages that an appeal shall lie against an order passed by the settlement officer in connection with any settlement operation to the settlement commissioner. Regulation 204 says that no suit or proceeding shall, unless otherwise expressly provided by the provided in this regulation, lie or be instituted in any civil court with respect to any matter arising under and provided for by this regulation. Please check with this. Paragraph. It appears from the material on record as well as submission made on behalf of the petitioner that the petitioner has been able to make out an arguable case. Paragraph, the petitioner is directed to serve copy of the application along with annexure thereto upon the opposite parties, upon the respondents, and file affidavit of service on the adjourned date. Paragraph, the matter be placed before the next available session.
Applied.
Next.
Item number 14. WPS 338 of 2025.
I appeal for the petition, your lordship. There is an innocuous prayer, but the service has not yet been effected. So I'll come back on Thursday, your lord. Very innocuous prayer,
Short matter.
very short matter.
Since service upon the respondents is not complete, let the matter stand over till 7th.
Item number 15. WPS 350 of 2025.
Anyone for the petitioner?
Yes, for the petition. Pass on. Service is complete.
Passed on.
Item 16. WPS 358 of
I
2025.
am for the petitioner. Here, service is complete, my lord, because it has served on 31st of July 2025. There is the direction I require, my lord, because the representation is pending here.
Who is appearing?
Good, look, Babita Das used to appear, my lord, for the revenue. It has been served. It has been served on 31/7/2025, my lord. So I have not filed the affidavit of service, but
Who is appearing for the administration?
Miss Babita Das.
Where is she?
I'll ask, my lord, because only the representation is pending that has to be disposed of within certain time period, my lord.
Yes, but in her
No, no.
absence.
I'll ask her to come. Let it be passed over, my lord, I'll ask it.
Passed on.
Item number 17.
My lord, in this
My
matter,
lord,
my
hearing
lord,
both for the
I'm
petition.
raising a preliminary objection to the maintainability of the writ petition, my lord. If my lord permits, then I make my submission on that. My lord, they have challenged an order passed by a officer, which is at page 493, dated 15 January 2025, My lord, under the Andaman and Nicobar Island Land Reform Regulations 1966 and specifically Regulation 28, every order passed by a revenue officer is appealable right up to the Lieutenant Governor level. So, my lord, this order, my lord, has been passed by the Assistant Commissioner, who's also the also a revenue officer, and this is appealable, my lord, before before an appellate authority. So, my lord, they can avail of their statutory remedy, my lord, before approaching the writ court. So, therefore, my lord, my humble submission is, my lord, the writ should be dismissed on this ground, my lord.
Yes,
May I proceed, my lord? My lord, the writ petitioner, my lord, it pertains to, my lord, claim of tsunami compensation, my lord.
whatever it may be, under 28, there's a bar, you're aware?
No, my lord, I will answer to that. There is no bar, my lord. Earlier, we have invoked writ jurisdiction. There was several matters filed before the honorable before this honorable court. Orders were passed. Pursuant to the order, the authority was directed to reassess the compensation.
See, the maintainability issue was not before the court when it was dealt with. But now that it is before this court.
My lord,
In fact, the Supreme Court has specifically, they have on their own showing, my lord, Supreme Court has permitted them to challenge the order before the appropriate authority. Supreme Court doesn't say High Court. So, my lord, they
to withdraw and challenge before the appropriate authority.
My lord, kindly allow me to address this point, my lord. Kindly allow me to address this point. My lord, here the issue is, my lord, my learned friends raised a point, my lord, in connection to the regulation of 1966. That is in case of jurisdiction exercised by the revenue officer. Here, this is not an issue in connection to the revenue claim or any claim over the land. Here, the issue is entirely different. Tsunami compensation doesn't cover by the regulation itself. And I am entitled to seek compensation under the package granted by the central government for the tsunami, for the aggrieved person due to tsunami. So, my lord, my humble submission, my lord, the writ petition is maintainable. It is not barred under the regulation because the scope and mandate of the regulation is entirely different. It doesn't cover the issue of tsunami.
Have you served the Union of
Yes.
India? Have you served the Union of India?
Yes, it has been found. That is why my learned friend is appearing.
No, he's for the state. Yes?
dispute is with us, my lord. If they made a party, they should serve Union India also, but their whole claim is based on a grant made under the 66 regulations. My lord, in my submission.
No, my lord, this is incorrect, my lord. This is incorrect.
They have sought compensation by virtue of being under a grant. If the order itself will show.
My lord, this is my petition. My senior friend, if allows me to.
No, I'm raising an objection.
This is my petition. My learned friend has already raised an issue of maintainability. Now, may I respond to this? I'm responding. There is no debate. My response to the maintainability is that the issue forms subject matter of the present writ petition doesn't cover under the 1966 regulation, because the scope and mandate of the 1966 regulation is entirely different. This order was the order under challenge in the writ petition was not passed in under the regulation 1966 regulation. So there is no embargo. If my learned friend shows from the impugned order that the order was passed in terms of 1966 regulation, the officer has exercised his jurisdiction in 1966 regulation. My lord, I will close my argument. The moment if my learned friend shows from the impugned order one line that the authority has exercised in terms of 1966 regulation, I will stop.
Compensation as found from the order.
Yes, my lord. My lord, kindly allow me to proceed, my lord. May I show, my lord? I will
stop the Union of India and come back. Because they are the persons who need to pay the compensation, I think, if it at all this is allowed.
Yes, my lord, because we have received funds from them, so we are answerable to them for any disbursal of funds.
But my lord, here my lord, the administration is to first assess the compensation. Here that has,
The Union of India. Where is your affidavit of service?
Milord, my advocate on record, Milord.
Not filed, it may be fixed on any date 7th. I will file the affidavit of service
She is not ready with the affidavit of service.
because it has
I'm-
filed through me.
I'm extremely sorry, Milord.
I cannot accept. It has to be a physical service. Mails are, now we are not, that's our, mails are not open half the time. Please serve and
Then I will serve physically.
she needs to serve physically. It has been sent through mail, I believe.
Yes.
Milord,
That-
I'm
Service,
sorry, Milord. I'm sorry, Milord. I was not aware of it. I'm sorry, Milord.
since service upon the Union of India is not complete, comma, the matter be placed before the next available circuit bench.
Right.
Grateful, Milord. Grateful.
Next.
Item number 18, WPA 290 of 2025.
My lordship, in this matter, I am for the petitioner, your lordship.
Yes.
Last occasion, I submitted before this honorable court that the service upon the private responders is incomplete. From the track report, your lordship, I found that the private responders received the
It's an affidavit of service, sir.
lordship. I will file the affidavit service. Today only I have got this, your lordship. Last 2 days, the Indian Post online is not working, your lordship. So I have got this today morning from other site, your lordship. So I have not filed the affidavit service.
Will you
So
come back tomorrow?
day after tomorrow, your lordship, so that I can.
Yes.
Yes, I am for official respondent.
Day after tomorrow?
Yes, your lordship.
Since service upon the private respondent is still not complete, comma. Let the matter stand over till 6th.
19, WPA 316 of 2025. Item 19,
My lord, I'm there for the petition. The other side has to file their opposition.
Who is appearing?
I believe Tabrez, sir.
Yes?
I believe Tabrez, sir, appears.
Where is he? Time was sought. None appears for the
Milord, I'm here for the official response.
Tabrez.
Here for the administration.
Society.
So who wanted to file the opposition? You are for 3 and 4,
Yes, ma'am.
the Central Cooperative Welfare Society.
No,
No.
we are for the registrar corporate.
Tabrez, sir, appears for cooperative society.
So 3 and 4 wanted to file. None appears for respondent numbers 3 and 4. No affidavit in opposition has been filed. The matter be placed before the next available circuit bench. Earlier circuit also same order was there. There was no opposition. Next.
One and two.
item 20, WPA 328 of 2025.
For the respondent, lordship.
Just I need 1 day's accommodation.
I already filed the report,
The
lordship.
petitioner number 1 is an advocate, senior advocate of this bar. Some protection has been granted by this court while entertaining the writ. They were direct to file the report, they have filed the report. Let me see the color of the report, let me come back tomorrow. Let me come back.
You're the petitioner, right?
I'm the petitioners, there are
On
3
prayer
names.
of the petitioners, the matter is adjourned for the day.
I'm ready.
Item number 21, WPA 3 on of 2025.
My lord, I appear for the petitioner in this matter. There was an interim order to provide electric connection to my dwelling unit.
Who is
However,
appearing
the
for
authority concerned has not provided the connection yet.
Who is appearing for the department?
My lord, my learned brother, Mr. Mishra is appearing, he is online.
Yes.
The interim order has not been complied yet. My lord. It has been more than 2 weeks. I mean, this is the 3rd or 4th week, I believe.
Hello, Lordship.
Yes.
Petitioner has not completed the earthing. As such, we have not provided. It is under the process, Lordship. We will provide it.
Not completed the earthing.
Earthing was already
Yes.
complete. We
Yes,
intimate
Lordship.
as
That
well.
is the difficulty. Otherwise,
Yes.
if earthing is completed, we will provide the electricity
Was pointed
connection.
out was that it is not proper. We just cleared it off and then we intimate the AE office as well.
Earthing has been completed.
It has been.
Lordship, let me take the instruction. If earthing is completed, Lordship, I will ask the department to provide the electricity connection.
Tomorrow, please come back tomorrow with the instructions.
Day after tomorrow, Lordship.
Learned counsel for the petitioner submits that despite a direction of this court, given V-Day order dated July 11, 2025, comma, electricity connection in his premises has not been restored. The necessary earthing has been completed by the petitioner. Paragraph, learned counsel for the respondent seeks to take instructions in this matter. Paragraph, let the matter appear under the same heading on 6th day after.
Obliged, Lordship.
My lord, I am for the petition, my lord.
Lordship, I am appearing for the respondent. Lordship, here difficulty is that the petitioner is already having one connection. I have the document. Let it be tomorrow. I will produce the document.
Yes, you agree that you have a connection. How
My
can you
lord.
have a second connection?
My lord, that connection in the name of different person.
But it cannot be in the same
In
premises.
the same premises. In the same premises.
My lord,
Two connections be in the same premises.
I think
Can't be, you're aware. Withdraw
My
this. I have to dismiss this.
I may be allowed to withdraw this. I may be allowed to withdraw this.
Not press this.
My lord.
Learned counsel for the petitioner submits that the petitioner does not intend to proceed with the matter any further. Paragraph in view of the above, comma, the application is dismissed for non-prosecution.
I'm
Obliged, deeply obliged, Lords.
Next.
Item number 23.
My lord, applies for the petition. I am
Whose
just saying
order is under contempt here?
they already.
It's a contempt application.
The honorable judge is not available, my lord. I think Justice Moshui Bhattacharya.
I'm just praying for not to demand.
Is it complied?
Yes,
According
Your
to us, it is complied, my lord. I don't know if they are saying.
Compliance. You need to come back with an affidavit in that case.
Yes, my lord, we'll file an affidavit of compliance.
Complied with, you need to file an affidavit.
Yes, my lord, we'll file. But actually, last time there was some submission made across the bar that they may withdraw, etc. That is why we'll file an affidavit of compliance, my lord. Maybe there is some dispute. I'll file that.
I'll take inspection.
They have to come back with an affidavit of compliance. Otherwise, how do you take this action? You can file an exception to that if you want to, right?
We'll file.
The alleged contemptor seeks to use an affidavit of compliance, demonstrating compliance of the order under contempt. Paragraph on prayer of the applicant / petitioner, comma, liberty is granted to use an exception to the affidavit, comma, if required. The matter be placed before the next available settlement.
Right.
Next. These 8 matters.
Item number 24. Here are 24.
24 to 30 I'm saying next topic, my lord. I think it's not available, it's not in mailing.
Not available?
It's a coverage, my lord. Seniors, my lord.
He has gone to mail on personal ground, my lord. I am also helpless to make any submission.
Learned counsel for the petitioner submits that the matter may be fixed before the next available circuit bench. Since learned counsel for the petitioner is not available this week. Paragraph in view of the above, comma, the matter be placed before the next available circuit bench. 24 to
31.
31. Same order, huh? Separate orders, but the same.
Item number 32, WPS 668 of 2023.
My lord, in item number 32, my senior appears for the private respondent. I'm paying for not to them.
I pay for respondent.
Matters. Today she says. On prayer of the private respondent, the matter is for the day. Tomorrow, no Passover, no, not today.
My lord,
You need to be ready.
my lord.
Next.
Item number 33, WPA 912 of 2023.
I pay for the respondent.
Petitioner? Mr. Jaipal is.
Yes, I'm there. I could not find Mr. Nadim Akhtar Khan because he is main contender, Your Lordship.
I am for official
Some of
respondent.
the authorities have been challenged, but he would oppose my prayer. Because he is.
Have you served?
He's been appearing all through, Lord. He's been appearing all through. Even till last date, he was appearing. Or let it come tomorrow. Let it come tomorrow. Let it retain his position.
He's the private respondent.
Private.
Yes, my lord.
None appears for the private respondent. The matter is adjourned for the day.
Right.
Right, my lord.
Item number 34, WPA 90 of 2024.
And in item number 34, I'm praying for not to them. My lord. He's on his legs before the other court.
34, my lord, can in this case, my lord, the case of the petitioner, my lord, is under consideration. My lord will find in earlier orders this is recorded. So, my lord, that process has not been completed. So, my lord, this matter can be adjourned to the next circuit as well. If the other side is not objecting to the adjournment, because if my lord sees in the early orders record that under a scheme, my lord, their case is under consideration.
So the application is still pending. They filed an application. for the authority
Yes, 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 madam.
to consider his case in the light of the guidelines dated 30th August.
Yes, my lord. That is still pending. So if otherwise, let it come tomorrow. Her senior will be there, my lord. No problem. I don't have whatever we do.
Situation will not develop, improve, right?
My lord.
It will be the same situation tomorrow also.
Yes, 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 thank you.
It shifted.
Yes,
Yes.
ma'am. Yes, ma'am.
Learned counsel for the respondents, official respondents submits that the application filed by the petitioner before the authority to consider his case in the light of the guidelines dated 30th August 2024 is still under consideration. Paragraph, in view of the above, comma, the matter be placed before the next available circuit.
My lord, would my lord be kind enough to just record on instructions, my lord, where my lord has said that I submit on instructions, because factual issue, sometimes there is a lapse in between.
Next.
Item number 35, WPA 111 of 2024.
Madam, item 35, I'm
For the respondent, 120.
4 and 5, madam, please for next item.
Submission is not. Lawyers, typically, I never stand in the way. But I'm accountable to my clients also, Your Lordship. Sufficient time has been granted.
Fine.
It's February 2024, it was final. It's almost more than 1 year.
You're the private respondent.
Right, madam.
Every day you have been taking time, sir. The affidavit in opposition is not ready as yet.
Not final.
7 days.
Right.
Circuit or no circuit, please serve within 7 days. Learned counsel for the 4th and 5th respondents seeks further extension of time to use the affidavit in opposition as sought. Paragraph, affidavit in opposition be filed within 7 days from date. Affidavit in reply, comma, if any comma, be filed within a week thereafter. Within a week from date and within a week thereafter. A week in matter. Paragraph, the matter be placed before the next available circuit.
Grateful.
Obliged.
Item number 36, WPA 224 of 2024.
My lord, in I respondents, my lord, my senior appears for the petitioner. We have filed our affidavit of service. The service
She's
upon-
appearing. Upon the added
respondents, my lord,
Who is appearing for them?
they were written unserved as insufficient address. But these address we have
It is
got
written
from a
unserved.
government document.
Service was? Shad Ali Roshan Bibi in services. Endorsement. Address cannot be located. You have to find out the correct address and serve.
This address we have got from a government document.
But you need to serve when you've included them, right? Find out.
Ma'am.
Affidavit of service filed by the petitioner is record. Since service upon the added respondents is not complete, comma, the matter be placed before the next available circuit bench. You need to find out the proper address.
Obliged.
Next.
Item number 37, WBA 327 of 2024.
Your Lordship, I am for the petitioner.
Yes. Response.
This is a case, Your Lordship, relating to subsidy. That is, the date of commencement of the work, Your Lordship, that got delayed due to COVID, Your Lordship. The entire, Your Lordship, the Andaman and Nicobar administration declared
And affidavit is
lockdown.
complete.
Yes, Your Lordship.
For final arguments, my lord. It is for final arguments.
You're ready today?
And it will take some time, but if my learned senior insists, then I'm there, my lord, no difficulty. But otherwise, it can go to the next circuit. It will take some time. It's a very voluminous
Because
file.
this is the issue, that the COVID period where the authorities have declared lockdown, due to that declaration on the particular date fixed, I could not commence my work. When they lifted the lockdown and the things got correct, Your Lordship, and everything was normal, I immediately started the work. So that period, whether it is required to be condoned in order to consider the issue relating to subsidy or not, that is the point. And this Honorable Court, Your Lordship, this is a second round of litigation. This Honorable Court, Your Lordship, in detail, Your Lordship, has kindly come to page number 322.
Yes.
Now, here, Your Lordship, the Honorable Court has discussed everything, Your Lordship. The relevant paragraph, Your Lordship, I am coming to
The
that.
same petitioners.
Yes, yes, same petition. This is the second round of litigation. Paragraph 24, Your Lordship, page number
Third round. In fact, this is the third round of litigation.
Third round, I'm sorry, yes. The aforesaid case is not applicable in the instant case for the reason that the claim was laid by the respondent therein, relying on the
You're at
principle of
paragraph?
24, Your Lordship.
Yes.
Rest, Your Lordship, is a recording of the Honorable Court, Your Lordship, relating to when I approached this Honorable Court for, in the first round of litigation, what actually has happened. All those things are given in the beginning. Now, paragraph 24, the aforesaid case is not applicable in the instant case for the reason that the claim was laid by the respondent, therein relying on the principle of promissory estoppel. An exemption was sought in relation to tax and duties otherwise payable under the statute. But before any investment is done by the respondent, the government decided to amend, dissign, and or revoke the said policy, and therefore the apex court held that it shall not tantamount to altering the position nor creates a vested right upon the investor to claim the concession of tax and duties. The instant case is founded upon the power to relax any of the clauses or the conditions under the said scheme. The petitioner approached the court seeking the direction upon the authority to invoke such powers, and it admits no ambiguity that such invocation of power must withstand on the principle of reasonability and rationality. It is within the competence of the authority upon whom the power of relaxation is vested upon either to relax or refuse to relax any of the clauses or the conditions of the scheme, but such decision must be reasonable and not arbitrary. It appears that the Lieutenant Governor has not taken into account the fact that the moment the petitioner commenced the commercial activities within 9 days from the date of the lifting of the restriction imposed COVID-19, had there not been any lockdown declared on 22/3/2020, or at least the operation of the flight would not have been stopped from 19/3/2020, the petitioner may have been in a position to commence the commercial production. Such factors have to be considered in the light of the relevant documents to be produced in the regard and the infrastructure having put in place on or before 19/3/2020. Since the power of relaxation is conferred upon the lieutenant of the court should be slow in usurping such power and grant the relief to the petitioner. In view of the above, the order dated this passed by lieutenant is hereby set aside. The matter is remitted back to him to consider the said application afresh after taking into consideration whether the infrastructures prior to the stoppage of the flight operation was such which would in the event lockdown having not declared inures the petitioner to commence the commercial operation production on or before 31/3/2020. Now, Your Lordship may kindly come to the order of the Lieutenant Governor, Your Lordship.
P35.
335.
Yes.
Your Lordship, just a minute. Your Lordship, it starts operative portion, starts from page number 337. May I place, Your Lordship?
Yes.
A. Approval of building plan. From the reply submitted by APWD with a letter dated this, it is observed that approval of building plan of Mrs. Reflex Industries Private Limited was accorded by the Office of the Chief Engineer and Town Planner APWD on 20th March 2020, which was further communicated to the firm by Panchayat Secretary Mithakadi Gram Panchayat on 20th March 2020. Further, as per clause 11.1.1 of National Building Code, Part 1 read as, no person shall carry out any development, erect, re-erect or make alterations or demolish any building or cause the same to be done without first obtaining a separate permit for each such development building from the authority. No permit shall, however, be required for works referred to in 12.1.2.1 and 12.4.1. Further report received from Executive Engineer, Chief Engineer APWD, with a letter dated this, has stated that although structural members consisting of channels and pipes were prefabricated that requires short duration to erect, the walling and flooring requires considerable amount of time. Inference drawn. It would have been practically impossible for any enterprise to develop an area measuring 3,000 square meter, construct building, install the plant and machinery, and commission the same within 11 days from the date of approval of building plan on 20th March 2020 to make it operational before 31/3/2020. Now, Your Lordship, the Honorable High Court has said that you look into the infrastructure, what development has already been done. They are not there to speculate things that on 20th March 2020, the order, the approval has been granted. So 11 days, it is not possible to do it. So one inference, one hypothetical inference is drawn that it is not possible, so it could not have been done. This is not a direction of the Honorable High Court. Honorable High Court has said that you see, go there and see what are the infrastructure or what and all has already been done there. And on the basis of that, you have to calculate that within 11 days, it was possible for the person concerned to commence the operation on. That was required to be looked into because, Your Lordship, 19th March, the lockdown was announced. Now, Your Lordship, in May, it was lifted. Within 9 days, I started the commercial operation. When within 9 days I could do it, then where is the question of these 11 days? Then consent to operate from Andaman and Nicobar Pollution Control Committee. From the reply received from ANPCC Department of Science and Technology with a letter dated this, it is observed that as per Section 25 of Water Act 1974 and Section 21, it is mandatory and responsibility of any unit to obtain consent to establish from ANPCC before establishment of industry and consent to operate immediately after establishment of industry and before commencement of production. In the instant case, the firm Mrs. Reflex Industries Private Limited have neither applied nor obtained consent to establish from ANPCC. However, the firm had only applied to consent to operate only on 9th July 2020 and was granted consent to operate by ANPCC only on 22/4/2021. So that Pollution Control Committee will look into it if there is violation of or any other thing is there, the Pollution Control Committee will consider it, and whatever adjudication is required to be done, it will be done by the committee. But whether these factors are required to be looked into at this stage to deny subsidy. And moreover, Pollution Control Committee has already granted me the consent to operate. Even if it is late or prior, it is immaterial. Then inference drawn. From the above information received from Andaman and Nicobar Pollution Control Committee, it is evident the firm have neither applied nor obtained consent to establish and applied only for consent to operate on this. And ANPCC issued consent to operate only on this. Therefore, it would have been illegal for the unit to commence the production before this. On what basis they are saying illegal to operate, nobody knows. Because there is no clause in the scheme. There is no provision under the Pollution Control Act itself or regulation itself that the production or the commencement will become automatically illegal if that permission has not been obtained. Because permission, if we are applying, it can be granted lately also. So there is no bar, Your Lordship, that I cannot commence my production unless and until that consent to operate is obtained. Secondly, even in the subsidy scheme also, this aspect is not there. License under Factories Act. From the reply received from Department of Labour, Employment and Training, where they letter dated this, it is observed that as per Section 2MI and II, obtaining license under Factories Act 1948 and Section 4, which reads as, no premises shall be used as factory nor any manufacturing process carried on in any factory without the registration of the premises and the grant of license to the factory by the Chief Inspector. In the instant case, the firm was granted registration and license to work as a factory only on this by the Chief Inspector of Factories. Inference drawn. From the document submitted by Chief Inspector of Factories, it is evident that license under Factories Act was granted only on this. Therefore, it would have been illegal for the unit to commence its activity before this. Further, the unit had commenced operation on 4/6/2020, which is much before obtaining license, and such operation without obtaining license under Factory Act would be illegal. Again, the same thing, Your Lordship. License under Food and Safety Act, same thing. Fire clearance, this all the things, Your Lordship. Then kindly see the procurement. Yes, this license food safety is the same thing. Fire clearance is also the same thing. That it was obtained on a particular date, and therefore the unit cannot commence its commercial. Yes. Prior to that. Now, procurement, transportation, installation, commissioning of plant and the department approached the Port Management Board to ascertain the dates of arrival of cargo ships from Chennai to Port Blair. The letter dated this received from the Harbour Master has furnished the dates of arrival of the cargo of this. These are the date of arrival. From the above, it can be seen that majority of the plant and machineries of the petitioner arrived in 3rd and 4th week of March 2020. Which would leave the petitioner practically no time to install the plant and machinery and commission the same to make it operational before 31st/3/2020. Again, speculation. Because if the dates are looked into, that before the lockdown was announced, all materials were already there. Only one material came on 27/3/2020. However, Your Lordship, that is because even they have not gone to the particular premises to see that these materials have been installed or not. They have not visited the spot. Then, from the above, it is evident that it would have been practically impossible for any industrial unit for undertaking and completion of following works within a period of 11 days from the date of approval of this. The interests drawn are as under. Now, Your Lordship, same thing they have repeated. So, Your Lordship, what is the direction of the Honorable High Court? Honorable High Court has held that you go to the place because you have to find out what infrastructure is there in the premises. In order to find out what infrastructure is there, they have to calculate the period. Now, when my materials came here, Your Lordship, the entire thing was 19/3, lockdown was there. It is nobody's case that from 19th March 2020 till June, I was doing the work. Your Lordship can understand that if I am doing the work, that means I have taken time to carry out the work for 2 months. March, April, May, 3 months I was doing the work. It is nobody's case because they themselves are accepting that from 19th March till the lifting of the lockdown, that is on 22nd or 23rd May 2020, there was no work in entire Andaman and Nicobar Islands. It was, lockdown was there. So when the work was not done, that means, Your Lordship, on 19th March 2020, what was my position? The same position was there on 24th or 23rd May 2025. There was nothing, no work done. So that particular day on till 4th June, I did the commercial production. Commencing the commercial production is not disputed. They are not denying it. On 4th June, it has been done. Admitted fact. So, Your Lordship, just on the basis of certain licenses and materials, can we come to a conclusion that it is not possible? When they have specifically not denied the date of commercial commencement of commercial production, they have not denied it anywhere. So, Your Lordship, the first round of litigation also.
This is the second round. Why do you say
Third,
it's the
third.
third round?
Third round, Your Lordship.
The first round of litigation you show. Oh, the first round is before the authority, you say.
No, Your Lordship.
Okay.
Before, yes. That is for
The earlier order is the first round.
no. Earlier order is the second one. 295, Your Lordship. First order. 94. Division bench. It went up to the Honorable Division Bench. It starts from 292.
Oh, this was for consideration of the application, the first
Yes.
round.
First one, Your Lordship. Not only that, the court has made certain observation. So for that reason, they have been to the Honorable Division Bench. Page number 295 is the Division Bench order, Your Lordship.
Other matters least below.
No, why? It's only 3:30.
Now, Your Lordship may kindly come to paragraph 13, Division Bench of this Honorable Court.
Yes.
In the aforesaid facts and circumstances, we modify the order under appeal to the extent that the respondent number 1 shall consider the application for subsidy in the light of the observations made herein above and take a decision whether by extending the time period fixed under the said scheme for commencing commercial production for availing subsidy, the benefits can be given to the appellants. The respondent number 1 shall decide the application made by the appellants in this perspective and dispose of the same within 6 weeks from the date of communication of a copy of this order download from the website by affording appellants a reasonable opportunity of hearing. The order shall be communicated. Now, Your Lordship, certain observation has been made that paragraph 11, Your Lordship, that observation is important. As stated in above, according to us, the last date of commencing commercial production under the said scheme was 31st March 2020. But the claims could be lodged within 1 year from the date of commencement of commercial production. Usually, they have raised a very peculiar point that my claim was made on a particular date, that is on some October 2020. And that is the reason why it is time barred. That type of argument was advanced. So the court has negated that argument. The scheme only for the purpose of claiming subsidy remained in subsistence for 1 year, period from 31st March to 31st March 2021. The lodgement of claim by the appellant is within 1 year from 4th June 2020. The relevant question is whether the appellants are entitled to the subsidy after having commenced commercial production on 4th June 2020 instead of 31st March 2020. We find that clause 13 of the scheme gives the administrator, being respondent number 1, the authority to relax any clause under the said scheme. It is true that one day national lockdown was observed on this and full lockdown all over India started from 24th March 2020. So at least 7 days prior to the expiry of the last date for commencing commercial production, the lockdown intervened, which is to public knowledge. It is therefore necessary for the respondent to consider claims applications in this perspective. So, Your Lordship, again, this particular thing was discussed by the single bench in the second. Again, they rejected on the same ground, Your Lordship. Almost the same ground was there. The order is at page number 306. Yes. Now, if Your Lordship would see, kindly see, Your Lordship, page number 309, the last paragraph, Your Lordship. And subsequent paragraphs, Your Lordship, from 310. More or less, Your Lordship, same type of grounds. But the peculiar thing is that, Your Lordship, the grounds which have been taken up in the third order, Your Lordship, those all grounds are new grounds. Only the one, I think, Your Lordship, that is about allotment of space at Mitagadi and something of that kind, NOC for obtaining fire clearance. That was possibly the same. Rest, Your Lordship, this Honorable Court has considered this order and found that these are not the criteria which are required to be looked into as per the provisions of the scheme. When all these things are not there, this Honorable Court adjudicated and directed the authority to consider it again. And then now, Your Lordship, this order has been passed. So my submission is, Your Lordship, this order is required to be set aside. They have to implement practically they have to implement the order passed by this Honorable Court in its true spirit, Your Lordship. That has to be done.
That's a message.
Yes.
Yes, Mr.
My lord, in my humble submission, my lord, the order passed is strictly in terms of the order passed by the learned single judge on 29 September 2023. Kindly have that order, page 322. Just a few relevant portions. Kindly have, my lord, page 322, paragraph 2. The dispute relates to extending the benefits of the aforesaid scheme, providing the subsidy for the investment or infrastructure which could be extended to MSME. Now, the next few words are very important, my lord. Provided the commercial production commences on or before 31st March 2020. Now, kindly come, this is the earlier round. Now, kindly come to paragraph 8, my lord, at page 327. It is contended by, this is their argument, it is contended by learned advocate for the petitioner that commercial production could not commence because of lockdown having declared in the country, though the petitioner was prepared to commence production on or before 31st March 2020. Now, kindly see after that, the paragraph 26 at page 333. What is the consideration? Because this was a fresh direction and hence the reasons are different in this order. Because this issue was considered in light of the division benches, the learned single judge's specific direction. Para 26, page 333. It appears that the Lieutenant Governor has not taken into account the fact that the moment the petitioner commenced the commercial activities within 9 days from the date of lifting of restriction imposed for COVID-19, had there not been any lockdown declared on 22nd March 2020, or at least the operation of the flight would not have been stopped or from 19 March 2020, the petitioner may have been in a position to commence commercial production. So this is the observation of the Honorable Court. Then kindly see, my lord, what is the consideration that the learned single judge has directed? Such para 27, such factors have to be considered in light of relevant documents to be produced in this regard and infrastructure put in place on or before 13 March 2020. And then, my lord, will see para 30. The matter is remitted back to him, that is the Lieutenant Governor, to consider the said application afresh after taking into consideration whether the infrastructure prior to stoppage of flight operation was such which would, in the event of lockdown having not declared, ensure the petitioner to commence commercial production on or before 31st March 2020. So the Lieutenant Governor was required to apply his mind as to whether the status of the project as emanating on the day when the lockdown was declared was such that had the lockdown not been declared, the petitioner would have been in a position to commence commercial production. Now, this is exactly what the Lieutenant Governor has done from page 335 onwards. Because, my lord, what is this consider? Kindly see it's a very detailed order, and my lord may kindly bear in mind that subsidy is not a right, my lord. Eventually it is, and the scheme is not in existence anymore. So despite that, because in view of in deference to the court's direction, the case of the petitioner is being considered under a scheme which is non-existent as on date. Now, kindly see after page 337, whereas the last recital, whereas the matter is examined afresh after obtaining reports pertaining to the unit of reflex industries from various line departments of the administration, upon examining such documents, following inferences are drawn. So therefore, the court has in fact directed us to infer because what was existing on 13th March 2020, it cannot be ascertained without an inference, because we can't go back in time and check. So it can only be inferred the decision has to be based on inference. That is what the learned single judge has directed. Then kindly see each of the headings, each of the approvals have been considered and an inference is drawn. Kindly, for example, take the first inference. It would have been practically impossible for any enterprise to develop an area at measuring 3,000 square meter, construct building, install plant and machinery, and commission the same within 11 days from the date of approval of building plan to make it operational before 31st March 2020. Now, we are eventually, my lord, we are complying with the order passed by the learned. We cannot go behind the wisdom of that order. It is an order binding on us. So now we have not challenged that order. So eventually, my lord, we have to practically to carry out the direction, my lord, it can only be done in a practical manner, because the learned single judge has said that you examine whether it would have been possible for the petitioner to commence commercial production, or what else can be done.
Commence and completion is different. Yes.
Not
Yes.
Confused.
No, so we are saying it couldn't have been commenced, because for commencing commercial production, you have to construct the plant and machinery. Likewise, to commence commercial production, you need consent to operate from the Pollution Control Board. So these are prerequisites before you can commence production. License can you commence production without license under the Factories Act? You cannot. So therefore, this is, my lord, the painstaking effort has been made to implement the direction passed by the Honorable Court, and to see, my lord, that when, for example, kindly take license under Factories Act, which is at clause C at page 338. And the inference drawn from the document submitted by Chief Inspector of Factories, it is evident that license under Factories Act was granted only on 10th February 2021, which is much later. Therefore, it would have been illegal for the unit to commence activities before 10th February 21. So, assuming lockdown had not happened, would it be possible on 19th March 2020 to commence production? The case of the petitioner could have been appreciated if, for example, the license was there on 19th March 2020, but they could not commence production because lockdown was declared. But they did not have the essential requisites. They did not have the licenses which were required for them to commence production. Not only that, my lord, everything, my lord, has been, if my lord sees the order, my lord, each and every requirement for commencement of production, my lord, has been painstakingly examined. And in our humble submission, my lord, there is no other way in which, as far as the respondent is concerned, the order passed by the Honorable Court could have been implemented, because the Honorable Court said, you examine whether they could have commenced production. So to examine whether they could have commenced production, this is the only way that it can be done, is to examine their permissions, to examine whether they have the requisites to commence, for them to commence production before 31st March 2020. That is the only way. Otherwise, we can't guess. There is no other way to find out whether they could have commenced production before 31st March 2020. So, my lord, in my humble submission, there has been due application of mind, and the order has been implemented.
I reserve this.
Your Lordship, only short reply.
Just one last point. The learned single judge on the last occasion also specifically recorded that power of whether to grant relaxation is up to the discretion of the Lieutenant Governor, and the court did not pass a mandatory direction that you grant them this subsidy. What they are now inviting the court to do is to accept what they are saying and to grant them subsidy. If the petitioner, for the petitioner to succeed, in my humble submission, the petitioner has to give a viable alternative in which manner this order of the learned single judge could have been implemented, except to look at the permissions and infrastructure in place and to assess whether on 13th March 2020 they could have commenced production. They have not suggested that there was some other way other than to just accept what they're saying. So, my lord, in our humble submission, my lord, the order does not call for interference. Those are my submissions.
Your Lordship, one thing they are not disputing, that 4th June 2020, the commencement was there. They are not disputing that. Again, I am repeating, Your Lordship, from 19th March 2020 to 22nd May 2020, it is their own case that nothing was this. So, Your Lordship, the infrastructure which was there before 19th March 2020, that could not be developed within these 2 months. So, what has actually happened when they lifted the lockdown, Within 9 days, I completed it and started the commencement. Had there been no lockdown, before 31st March, I could have done it. That is the logic, Your Lordship. And physical inspection of the premises relating to infrastructure was never done by the authorities, which was in fact directed by this Honorable Court that it has to be looked into, that they have not done. So far as licenses are concerned, Your Lordship, I'm just repeating again, Your Lordship, those are not the prerequisite in terms of the scheme. Those are not there. In the scheme, nowhere it is stated. So this is my submission.
But without these licenses, could you have commenced the
Yes, Your Lordship.
operation?
Because if suppose I don't have this is only for the purpose of establishment and the commencement. But it is not practically, it is not that we are starting the entire thing, because we have made applications. Applications were there before the authorities. Now all licenses, their own case, all licenses I have already obtained. Now, Your Lordship,
After the reopening.
yes, because the lockdown was going on, Your Lordship. It was there up to this 28th February 2022. The COVID problem was there, already there. So my applications were there before the authority. Those applications were considered and subsequently it has been granted. If the authorities has considered that no, I have violated something, I have violated, and I have commenced the commercial production and I have violated. Under that particular act itself, they could have imposed any penalty or fine upon me. Did they do so? No, not even any authority. Fire license, food safety, and all those to pollution control and all. They have not imposed any fine upon me or any kind of this thing because of that COVID problem. Many people, they were not able to file the application because offices were closed. And many persons, even the officers, they were unable to adjudicate the applications because of this COVID period. So subsequently, it was granted. Licenses have been granted to me. So my submission, this is my submission.
Just one thing, my lord, our laws, in my humble submission, law cannot be observed in their breach merely because regulations are not strictly enforced. Doesn't mean that that will be a ground to say that we could have commenced commercial production without permissions. That cannot be a proposition, my lord, in my humble submission.
A precondition in the scheme, Your Lordship, then the matter would have been different. That is not a precondition. Last, Your Lordship, last thing, Your Lordship. Yes. Your Lordship, may kindly note that in the earlier order of the authority where my application was rejected, the authority has noted the point relating to obtaining of fire clear license. That particular thing was one of the grounds to reject my application. This Honorable Court, Your Lordship, sitting singly, Your Lordship, looked into that aspect and found that because that is not a precondition, and that is the reason why it has been set aside. So when obtaining of one license, Your Lordship, was not considered by the court to be a relevant factor to decide the issue related to subsidy, then how can there be consideration in respect of other licenses, Your Lordship? That may be looked into, Your Lordship.
Argument concluded, Judge.
My lord.
Your Lordship. Obliged, Lordship. June 2020.
Item number 38. WPF 405/24.
Madam, for the petition, here, today only I have filed my affidavit in reply. It can be taken up tomorrow.
Yes,
Copy of the hearing.
not served a copy.
Just, I'll serve. In course of the day, I'll serve.
Law, detailed hearing is required.
Yeah,
Excellent.
can be done. madam.
Affidavit in reply today you find.
Today, because I have received the affidavit in operation only on 31st.
Affidavit in reply filed by the petitioner is taken on record. Learned counsel for the respondent seeks to. Please serve.
You know, in
By-
course.
by today,
Well,
copy of the
bringing my lord. I
affidavit.
just feel it.
be served upon the respondents in course of this day. Paragraph, the matter will
I'm
be read in
serving
the
it,
next
Your
available circuit.
Serving it.
Next.
Item number 39. WPF 506/2024.
Your Lordship, I am for the petitioner. I have already filed my reply, Your Lordship. Copy has also been given.
Served?
Yes,
Who is appearing?
already filed. हम लोग reply भी file करती है. Copy भी देती.
You received the opposition.
Yes, we have received and we have filed the reply also and given the copy also. आज दी ना देखो. कुछ खास नहीं है इसमें. It's not that,
It requires some amount of hearing.
Your Lordship, very short point. That in that case, Your Lordship, it will require some time for hearing, because I have to satisfy this honorable court. This is these are seamen, Your Lordship. They are not covered under by the Central Administrative Tribunal. They are covered under the Merchant Shipping Act. So I can.
The seamen are covered.
Seamen are not covered.
Because PNB, their staff support them with board, and they are filing it before the tribunal only for claiming their rights. Judgments which is clearly specified that.
ठीक है, judgment का citation दे दो.
I'll give a citation, please, required a detail in it.
Affidavit reply is on record.
Yes, sir, we have filed.
Affidavit in reply used by the petitioners is taken on record. Next circuit in that case.
Yes.
The matter will be placed by consent of the parties. The matter will be placed before the on prayer of the parties. On prayer of the parties, the matter will be placed before the next circuit.
Item number 40, WPS 694 of 2024.
Reply given, Your copy has been given.
This not today, right?
This is a very short point is involved, Your Lordship.
Tomorrow.
Tomorrow, whether the CPWD manual, which is prevailing, which is the guide, the document, or Your Lordship, we can say the law governing the field relating to the works in the APWD can be amended by the authorities of APWD. That is the point.
By consent of the parties, the matter is adjourned for the day.
Item number 40 on WPS 7
Chart.
20 of 2024.
I have prepared the chart, Your Lordship. Copy दी बहुत अच्छा काम कर रहे हो.
Yes, fine.
कॉपी लगा कर काम कर लिया.
Let a copy be given to us, and my lord may permit us to examine and come back, my lord.
Your Lordship.
You've not served a copy.
Your Lordship, यही तो बात.
Let us examine, my lord. We'll have to take instructions.
When will you come back? Tomorrow?
Whenever your lordship, if there is urgency, then tomorrow, otherwise, my lord, later, whenever it commends to your lordship. And
by consent of the parties, the matter is adjourned for the day.
Item number 42,
So,
WPS 196 of 2025.
I'm appearing for official respondent, madam.
Petitioner,
I am for the respondent number 5, Your Lordship.
petitioner. 5. Petitioners are not being represented at all. Who is for 1 and 2? Respondent numbers 1 and 2.
क्या है? हमें 1 and 2
You are for 5 only, right? None appears for the petitioner. No accommodation is sought. The matter will be placed for the next available circuit.
petition open.
Item 43, WPA 209 of 2025.
I am for the private respondent.
Just not for two.
You are the petitioner. On prayer of the petitioner, the matter is adjourned for the day.
Item 44, WPA 265 of 2025.
For the petitioner,
Yes, official.
this day I have received the affidavit of opposition on file on behalf of the private respondent. So I need a week's
Want to
time.
come back with a reply?
Yes, Your Lordship. A week time, so you give your, my client is out of station, Your Lordship. And
Affidavit in opposition.
one more submission, Your Lordship. Already the interim order has been granted by the Honorable Court for 4 weeks, Your Lordship. That may be extended.
Let there be a further extension till 31st August, till the next circuit commences. Affidavit in opposition used by the private respondent is taken on record. Paragraph on prayer of the petitioner, liberty is granted to use a reply to the said affidavit. The matter be placed before the next available circuit bench. Paragraph, the interim order granted earlier is extended till 31st August 2025 or until further orders, comma, whichever is early. Two passed over matters, yes.
Pass over matters, item number 50, WPS 350 of 2025.
Lord, I will be appearing on behalf of the respondents, Lord. Just today, I have received a copy of the writ application.
You want to use an affidavit?
It can be disposed of, Lord. How far the Tahsildar can act on the basis of a decree of a civil court is a question which I have raised here. The preliminary decree has been passed. Right have been accrued in favor of the writ petitioner. In terms of local regulation, he has to hold mutation. Final decree, partition commissioners is a different thing, Lordship. So this needs to be gone in, Lordship. This is a pivotal issue which I have raised in the writ petition. The Tahsildar by one line, a cryptic order.
Page 51, my lord, what the Tehsildar has said.
That already challenged.
This order
This
is.
has been challenged in the present writ petition.
Since there is a mention, my lord, that there is.
I've been relegated to an appropriate forum. Tahsildar is the appropriate forum on this special regulation, Lord. This thing needs to be gone into, Lord.
Nothing has been decided in this order.
Nothing.
No, my lord, there is.
You are the petitioner.
I'm the petitioner.
He is the petitioner.
Why have you challenged this order?
No, because the Tahsildar have simply said me to go to the appropriate forum. But Tahsildar is the appropriate forum under the regulation 84. But in terms
Final
of
decree has not been passed, my
that's
lord.
not the concept. No, final decree, Lord. Lord, this exercise of drawing up a final decree, the right has been accrued in terms of the preliminary decree. He
You are
has to
referring to regulation?
84. This is how the Tahsildar would effect mutation based on acquisition of right. He has to hold mutation, partition commissioners exercise, final decree exercise to be done by a civil court. That's a settled law. But so far as effecting mutation is concerned, there are orders of our court. I will place those orders by coordinate bench. Once decree has been placed to the Tahsildar, he in terms of 84 has to effect mutation because rights have been created by a civil court. An appropriate forum, Lordship, is Tahsildar. How we can relegate to some other authority which has nothing to do with mutation. Mutation is to be done by Tahsildar and nobody else, not. Subdivision is vested with this deputy commissioner. It's not a case of subdivision. His simpliciter has to act in terms of, there are orders of our court. I will place those orders.
Because
on the point.
what you are saying is correct after the final decree, not after.
Yes,
No, even in an ideal case, there are orders of our court. I can place those orders.
Please place those orders.
But not today, not tomorrow. It can be. I will place those orders.
On prayer of the petitioner, the matter is adjourned for a day. Oblike. 16.
Item 16, WPS 350.
Respondents?
I will be appearing for the respondents.
Here the representation is at page 25 minutes.
Not disposed of as yet.
No, madam.
Page 25.
25 minutes. This is an application made before the deputy commissioner, who is the competent authority to subdivide the land. So I've made an representation before the same authority. It is pending. Notices were issued, my lord, but it has
Hearing has not been done.
not with compliance.
It is
How soon can you dispose of this application?
My lord, I have annexed the citizen charter. also.
3 months. 3 months.
Within 60 days, they will complete it. It is in the citizen charter, it is mentioned 60 days, and now they are asking for 3 months.
Within 1 month.
Since the consent of all the parties.
By consent, I'm alone. It's on the basis of sale date.
1 month. Dispose of the not on
60 days, sir, as per the matter.
That is over.
That's over, my lord.
60
It was
days
filed
from,
on 22/11/2024.
November 2024. Well, let it be 60 days. The innocuous prayer of the petitioner is for consideration of the representation submitted by her before the respondent, before the second respondent on 22nd November 2024 for subdividing the property purchased by her. The petitioner's name has been mutated and shown as the joint recorded tenant of the land. To the extent of 200 square meters. 200 square meters. Paragraph, heard learned counsels for the parties. Paragraph, the second respondent is that since the application filed by the petitioner is pending for a long time, the second respondent is directed to deal with the same and pass a reasoned order within 2 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, in accordance with law. Stop. The decision taken by the authority shall be communicated to the petitioner within 7 days thereafter.
Much obliged.
The writ petition being such and such is disposed of.